Thank you, Courtney. And thanks to GRS for having us here today to teach this course. So my name is Danielle Brennan. I am a partner here at Kaye Rembaum in the Palm Beach Gardens office. We have multiple office locations. Our largest office down in Pompano Beach. We have an office in Tampa, an office in Winter Haven, which is where Alan is. You'll see him at the second half of the presentation. And we also have office locations available in Miami-Dade by appointment. We are 22 attorneys. 9 of us are board certified in condominium and plan development law, including myself and Alan. And this is what we do day in, day out, provide expert legal services to community associations throughout the state of Florida. You need contract review, contract negotiation, amended and restating your governing documents, amending your governing documents, violation letters, you name it, we've done it. And most of the attorneys here have been with the firm for a very long time. So that tells you a lot about the culture of our law firm. Me personally, I've been here for almost 12 years now. So we're a big family, and we work as a team supporting our community associations. Like Jeff Solomon said, this is educational purposes only. Even though I am an attorney, I'm not providing you with any legal advice. Be sure to stay on the entire time and listen to what he has to say about the evaluation, because that's going to be the way that you get your certificate. And to reiterate on something Courtney said, this is only for condominium associations. If you are in a homeowners association, this class is not for you. Do not stay and watch, because really there are a lot of differences between HOAs and condominiums. Definitely go to kbrlegal.com onto that calendar like Courtney mentioned. We do offer HOA courses all the time, all for free. And we also have other courses that are specific to a particular topic, like assistance animals under the Fair Housing Act, updating your governing documents. And updating your governing documents is actually a course I'll be teaching next week at the Palm Beach L&L Expo. So if you're in the Palm Beach County area, go ahead and come see me. I'll be there. So let's go ahead and get started with the presentation. I'm going to pull it up and then I will share my screen. Jeff, remind me, they do get a copy of this once they complete their evaluation, correct?
Yeah, we'll go over that a little bit later. Once you submit your evaluations later, the confirmation screen after submission will have links for contact information for Danielle, Alan, and Courtney, as well as a link to download and save the slides. And lastly, within a couple of business days, more likely over the weekend, we'll have a recording of this video for review available on the website as well.
All right, awesome. So I'm going to go ahead and do the share now. And let me know, and I want to make sure that it's showing.
We can see it. And Danielle, while Danielle's getting prepped, I just want to mention everybody, like Christine typed in the Q&A, please do not let us know you're here in the Q&A. You don't need to do that, okay? If you can see the Q&A, if you can hear us and see us, and you can see all the features available on Zoom, that means you are properly here and properly signed in. No need to go in there and type, hey, can you see me? Am I here? The link that you get after you register, that link that everybody gets is unique to every one of you. That is your sign in. So by clicking that link to join, we know you're here. Danielle, back to you. Sorry for the interruption.
Okay, not a problem. So DBPR requires that the course be 4 hours long. So we're not doing this to you. The legislature is doing this to you, and requires that it includes certain topics, such as the first topic that I'll go through is structural integrity reserve studies and milestone inspections. Now, we have gotten the comment back that, why am I listening to this first hour? It doesn't apply to my condominium because we're not 3 stories or more. I do apologize in advance for that, but we are required by the state to teach this first topic to all condominium board members. So let's dive right into the milestone inspection requirements. A milestone inspection is a structural inspection of the building, including the load-bearing elements, the structural elements designed to provide support and stability for all the loads of that structure, and all of those members put together, creating a system. It's performed by an architect, an engineer, or a team of professionals with that lead architect or engineer. And it's to attest to the life safety and adequacy of the building structural components, and if possible, determining the general structural condition as it affects the building safety, and to determine any necessary maintenance, repair, or replacement of structural components if it's needed. The inspection would be of the foundation, masonry bearing walls, floor and roof systems, concrete framing systems, steel framing systems, windows, doors, wood framing, and the building facade. The milestone inspection is not to determine if the condition of the building is in compliance with Florida Building Code or Fire Safety Code. Again, it's just to determine the structural integrity and safety of the building and whether or not there might be some maintenance, repair, replacement needed to those components. Do we need a milestone inspection? So the milestone inspection requirements, again, are only for those condominium buildings that are 3 stories or more, and that is in whole or in part a residential condominium as opposed to, let's say, a commercial condominium. You don't really need to ask yourself the question, do we need a milestone inspection? Because ultimately, the local building official is going to be sending the association a notice to say, hey, you're such and such years old, you need to do your milestone inspection, and that'll get the process going. If the condominium is purely commercial, you do not need to get a milestone inspection, or if it's a single family, 2 family, 3 family, or 4 family dwelling with 3 or fewer habitable stories above ground, you do not need to get the milestone inspection. Just as a note, that the 4 family dwelling is underlined there because that was a recent addition from the last legislative session. Now, as far as mixed use and condominium hotels go, they still do have to comply with the milestone inspection requirements, and each part of that mixed use, or let's say it's like a vertical subdivision where there's a portion of it that's residential, a portion of it that's commercial, that each part is going to be responsible for their own costs for their portion of the building. So, when do you need a milestone inspection? The milestone inspection has to be performed by December 31st of the year in which your building reaches 30 years of age. Now, that's calculated based upon the date of the certificate of occupancy for that building. And if that date is not available, then the date of issuance of the building's certificate of occupancy is the date of occupancy as evidenced by any record of the local building official. If your building reached 30 years of age before July 1st of 2022, you must have performed your milestone inspection before December 31st of 2024, which just passed. If a building reached 30 years after that July 1st, 2022, and before December 31st, 2024, then your milestone inspection report must be performed before December 31st of 2025. And once you have that initial milestone inspection done, you have to perform that milestone inspection every 10 years after that first one. So every 10 years, you'll be doing another milestone inspection. Now, the local local enforcement agency can require that the initial milestone inspection be performed by December 31st of the year in which your building reaches 25 years of age instead of those 30 years, based on local circumstances, like maybe you're particularly close to the intercoastal or the ocean where that salt water may have accelerated deterioration of your foundational structures, your structural components of your building. In that case, the local enforcement agency may require that your milestone inspection be done sooner than the 30 years. The local enforcement agency can also extend the due date for the initial milestone inspection if there's good cause shown that the inspection cannot be completed if the owners of the building here, the association, have entered into a contract with an architect or engineer to perform the milestone inspection, and the inspection can't reasonably be completed before the deadline, or there's some other circumstance to justify that extension. If your milestone inspection report was prepared before July 1st of 2022, it might be accepted by the local enforcement agency if the inspection and report substantially complies with the milestone inspection requirements, which we'll talk about in a bit. Regardless of when the inspection was completed, you still have to notify the unit owners, and we'll talk about what that notice requirement is in just a moment. If a previous inspection report is accepted by the local enforcement agency, then that previous inspection is deemed the milestone inspection, and then the deadline for providing the subsequent 10-year milestone inspection is based on the date of the accepted previous inspection. So you've been provided with written notice from your local building official that you need to do the milestone inspection. Now what? The association, once it receives that notice, then has to notify the unit owners of the required milestone inspection within 14 days after receipt of that notice. And you have to provide them the date that the milestone inspection must be completed by. Now, the milestone inspection consists of two different phases, phase 1 and phase 2. Phase 1 is a visual examination of habitable and non-habitable areas of a building, including those major structural components, and to provide a qualitative assessment of the structural conditions of the building. The engineer or the architect who does that phase 1 milestone inspection, has to prepare and submit an inspection report, and it has to be completed within 180 days of receiving the notice from the local enforcement agency. The completion of a phase 1 means that the engineer or architect who did that phase 1 inspection has created the report and submits the report by email, US mail, or commercial delivery service to the local enforcement agency. Now, I know at least for the unincorporated portions of Palm Beach County, Florida, there's an online form that the engineer or the architect would go to enter in all of the information and submit it via their online portal. I'm not sure what other municipalities have done, but at least for the unincorporated portions, I know that that does exist. So your engineer or architect who does the milestone inspection for you should absolutely know the manner in which the milestone inspection has to be submitted. If the architect or the engineer finds no signs of substantial structural deterioration, then you don't need a phase 2 inspection. So what is substantial structural deterioration? It's substantial structural distress or substantial structural weakness that negatively affects a building's general structural condition and integrity. Unless the engineer or the architect performing the inspection determines that surface imperfections are a sign of substantial structural deterioration, those surface imperfections won't constitute substantial structural deterioration. And that can be cracks, sagging, deflections, misalignments, signs of linkage, things like that on the surface may not be substantial structural deterioration. Now, if there is substantial structural deterioration, then we move on to the phase 2 milestone inspection. This can include destructive or non-destructive testing, depending upon what the engineer or the architect determines. It can be as extensive or as limited as necessary to allow the inspector to assess the areas of structural distress to confirm that the building is sound and safe for its intended use, and to recommend whatever program may be necessary to fully assess and repair the distressed and damaged portions of the building. If the phase 2 milestone inspection is required, then within 180 days of submitting that phase 1 inspection report, the inspector then has to submit a progress report for the phase 2 inspection to the local enforcement agency and have a timeline for completion of that phase 2 inspection. The inspector who does that phase 2 inspection has to prepare and submit an inspection report. And what has to go into that inspection report? Well, you have to put in the report the condominium, excuse me. What goes into it is the next thing. Apologies. Upon completion of that phase 1 or phase 2 milestone inspection, the inspector must submit a sealed copy of the inspection report with a separate summary at a minimum, explaining the material findings and recommendations in the inspection report to the association, the owner of the building that's not subject to the condominium form of ownership, or and the building official of the local government which has jurisdiction. So what does the inspection report need to have in it? Well, it has to bear the seal and signature of the engineer or architect who performed the inspection, indicate the manner and type of inspection forming the basis for the report, identify any substantial structural deterioration, describe the extent of that deterioration, identify recommended repairs for the deterioration, state whether unsafe or dangerous conditions were observed, recommend remedial or preventative repair, and identify and describe any items requiring further inspection. Once you have that inspection report, within 45 days of receiving it, the association has to distribute a copy of the inspector prepared summary of the inspection report to each owner, and that has to be sent by U.S. mail or personal delivery to the owner's mailing address, or it can be sent by email for those owners who have consented in writing to receive notice via electronic transmission. Now, you do have to provide this summary regardless of whatever the findings or recommendations are in the report. The association must also post a copy of the inspector prepared summary in a conspicuous piece on the property and publish the full report and the inspector prepared summary on the association's website if the association is required to have a website. And we will discuss the website requirements in topic 2 of the presentation. Now, the Board of County Commissioners or the municipal governing body can adopt an ordinance requiring that repairs be scheduled or begun within a specified time frame. However, whatever that might be, the repairs do have to be commenced no later than 365 days after receiving the report. And if the owner of the building fails to submit proof that repairs have been scheduled or have commenced for whatever substantial structural deterioration may have been identified in that phase 2 inspection report within that required time frame, then the local government must review and determine if this building is unsafe for human occupancy. Now, this is very important for all of our directors and officers to understand that if the officers or directors of an association willfully and knowingly fail to have a milestone inspection performed, such failure is a breach of their fiduciary duty. So pretty serious stuff here. A local enforcement agency can prescribe timelines and penalties with respect to compliance with the milestone inspection requirements. When we see penalties, that means money. So they can actually fine you for failure to timely have your milestone inspection done. The Florida Building Commission was required to adopt rules establishing a program for implementing milestone inspections within the Florida Building Code, and it had to include testing protocols, different forms, record maintenance requirements, and they did in fact do that. They added Chapter 18 to the Florida Building Code. It's called Minimum Requirements for the Mandatory Milestone Inspection, done back in August of 2024, and it does include some forms to be used during that milestone inspection. So now that we've handled the milestone inspection part of it, let's turn our eyes to the structural integrity, and then we'll talk some more about some additional requirements concerning the structure of the building. So what is a structural integrity reserve study? It's a study of reserve funds required for future major repairs and replacements to the items that are listed in what a lot of us refer to as baby G or little g items. It's the roof, the structure, fireproofing, fire protection, like the fire sprinkler systems, plumbing, electrical systems, waterproofing and exterior painting, windows and exterior doors if they're maintained by the association, and any other item that has a deferred maintenance expense or replacement that exceeds $10,000. And if you fail to replace it, would affect somehow the structural integrity of the building. For the association, community condominium associations having a condominium building or 3 stories or more in height, you are going to be subject to the structural integrity reserve study requirements, and it will have to be completed at least every 10 years. Of course, that means that buildings having less than 3 stories in height will not be subject to these requirements. Similar to the milestone inspection, single family, 2 family, 3 family dwellings with 3 or fewer habitable stories above ground are not subject to these requirements. Note, for whatever reason, they did not add the 4 family dwellings here. Any portion or component of a building that has not been submitted to the condominium form of ownership, or any portion or component of a building that's maintained by another party other than the association. Obviously, here, the intent of the structural integrity reserve study is to make sure that the association has funds to do the work it needs to do. So if it's not going to be maintained by the association, well, then it's not going to be something that's subject to the structural integrity reserve study items. And commercial condominiums are not required to have the structural integrity reserve study done. Now, the structural integrity reserve study is based on visual inspection of the condominium property. There is no phase 2 here where there may be destructive testing going on. It's only what would be referred to like as a phase 1 type of a milestone inspection, where it is visual only. The structural integrity reserve study must identify each item of the condominium property that's being inspected, provide the estimating remaining useful life, and the estimated replacement cost or deferred maintenance expense of that item, and provide a reserve funding schedule with a recommended annual reserve amount that would achieve that estimated replacement cost or deferred maintenance expense at the end of the remaining useful life of that asset. Similar to our milestone inspection requirements, an engineer or an architect can do the visual inspection portion of the structural integrity reserve study. But you can also have a person certified as a reserve specialist or a professional reserve analyst by the Community Association Institute or the Association of Professional Reserve Analysts to do the visual inspection portion of the structural integrity reserve study. Now, the reserve portion of it can be performed by any person who's qualified to do that reserve study. Associations that exist on or before July 1st of 2022, and you may be asking yourself why that date. That's when this particular law was put into place, which are unit owner controlled, had to have had their structural integrity reserve study completed by December 31st of 2024 for each of their condominium buildings having 3 stories or more in height. However, an association, if you're required to have a milestone inspection by December 31st of 2026, you can complete your structural integrity reserve study at the same time, so long as the structural integrity reserve study is completed by that December 31st, 2026 date. If your milestone inspection is required, or an inspection completed for a similar local requirement, here, this could be like the 40-year recertification requirements in Broward or Miami-Dade. If it was performed within the past 5 years and meets the structural integrity reserve study requirements, then that inspection can be used in place of the visual inspection portion of that structural integrity reserve study. So you have that structural integrity reserve study in hand. Now what do you do with it? Within 45 days after receiving the structural integrity reserve study, the association has to provide a copy to each owner, or provide each owner with notice that the completed study is available to them upon request. The copy of the study or notice has to be sent by U.S. mail or personal delivery to the address provided by the owner to fulfill the notice requirements, or can be sent by email if the owner has consented in writing to receive notice by electronic transmission. The association must also provide the division, meaning the Division of Florida Condominiums, Timeshares, and Mobile Homes, with a statement indicating that the study was complete and that the association did what it needed to do as far as the unit owner notice is concerned. The statement must be provided to the division in the manner established by the division using a form posted on the division's website. Once you have that structural integrity reserve study, you do have to keep that among the association's official records for at least 15 years. For those associations who do have the website, you do have to post that on the website, the structural integrity reserve study. Again, we'll talk more about the website requirements a little later in the presentation. Again, same thing with milestone inspections. If an officer or director willfully and knowingly failed to complete structural integrity reserve study, that failure is a breach of their fiduciary duty. So it is very serious implications here if you fail to do that. If an association is required to have a structural integrity reserve study, reserves have to be maintained for those items for which the association is responsible in accordance with the Declaration of Condominium. The reserve amount has to be based on whatever the visual inspection portion of the structural integrity reserve study is. The association can adjust the replacement reserve amounts annually to account for inflation and any changes in the estimates of the useful life or maybe the cost of the replacement deferred maintenance of that item. Certain items that are in the structural integrity reserve study may have an estimated useful life that's not something that can be determined or has a useful life of greater than 25 years. If that's the case, then the association is not required to reserve replacement costs for those items. However, the association must reserve the amount of deferred maintenance expense, if any, which is recommended by the structural integrity reserve study for those items. So waiving and reducing reserves, this is something that all condominium association boards are familiar with when it comes to the traditional reserves. Members of the unit owner controlled association can determine by a majority vote of the total voting interest to provide no reserves, that's a waiver of reserves, or less reserves, a reduction of reserves, than what is required by statute. However, for our budgets that are adopted on or after December 31st of 2024, there is no ability to waive or reduce your CEUs reserves, your structural integrity reserve study reserves. There is the option for alternative funding method, but that only applies to multi-condominium associations operating at least 25 condominiums. And I personally, I don't think I've ever had one with quite so many condominiums, so I'm not sure how many there are actually throughout the state of Florida that would fit into that niche right there. Reserve funds and any interests on those funds have to remain in the reserve account or accounts and may only be used for authorized reserve expenditures unless they're voted on by a majority of all the voting interests to be used for something else. However, that does not apply for our CEUs reserves for budgets adopted on or after December 31st of 2024. Those CEUs reserves funds are sacrosanct at this point. Now, when it comes to pooling in and of itself is not governed by Chapter 718, which is our Condominium Association, our Condominium Act. But pooling, generally speaking, is based upon a vote to use reserves for some other purpose. However, when it comes to mixing non-CEUs and CEUs reserves, it's better safe than sorry. You don't want to be taking out money which should have been for a CEUs reserve item. Again, these things are sacrosanct, so best to keep them in different pools if you are doing a pooling method and have separate accounts for these. If local building official determines that the entire condominium building is uninhabitable, the board, upon the approval of a majority of its members, can pause contributing to its reserves or reduce funding until the local building official determines that the building is habitable. This being that you put the money towards making your building habitable as opposed to funding these reserves. Any reserve account funds held by the association may be used based upon the board's determination to make that condominium building and its structures habitable. Once the building official has determined that the structure is habitable, then the association must immediately again start contributing to its reserves. So we've talked about our milestone inspection. We talked about our structural integrity reserve studies. What else is there? Well, as you heard me talk about with regard to the structural integrity reserve study, that particular requirement is only for unit owner controlled condominium associations. However, there is a developer requirement as well. Notwithstanding when that certificate of occupancy was issued or the height of the building, the developer has to include in its turnover inspection report. So this is a portion of that turnover inspection report, a structural integrity reserve study attesting to the required maintenance condition, useful life and replacement costs of the roof, structure, fireproofing, fire protection systems, plumbing, electrical systems, waterproofing, windows and exterior doors. And note that there's nothing in here pertaining to that $10,000 asset. Each contract for the sale of a residential unit that is entered into at this time has to contain in conspicuous type a disclosure regarding the milestone inspection or structural integrity reserve study. If there is no disclosure, then that contract is avoidable at the option of the purchaser prior to closing. If an association is not required to have a milestone inspection or a structural integrity reserve study, then the contract has to contain a disclosure that the association is not required to have that milestone inspection or structural integrity reserve study. If the association is required to perform a milestone inspection or a structural integrity reserve study and has not completed either of those, then the contract for sale of a residential unit has to contain a conspicuous type, a statement indicating that the association is required to have it but has not completed it. And if it has completed either the milestone inspection or structural integrity reserve study, then it has to contain a conspicuous type certain disclosures that are set forth in Florida statutes. Each prospective purchaser who has entered into a contract for the purchase of a unit is entitled, at the seller's expense, to a current copy of the inspector prepared summary of that milestone inspection report and the association's most recent structural integrity reserve study. And then once those reports are provided, there's a 3 business day right to cancel the sale contract upon written notice to the seller. And that right to void the contract cannot be waived. So certainly if you're a unit owner, you want to be making sure that you're complying with these items to make sure that you close that cancellation window as soon as possible. When it comes to disputes regarding the milestone inspections and structural integrity reserve studies, the term dispute will include the failure to obtain the milestone inspection report, the failure to obtain the structural integrity reserve study, the failure to fund reserves as required for the structural integrity reserve study, and the failure to make or provide necessary maintenance or repairs of the property recommended by either the milestone inspection or structural integrity reserve study. Now, even though these are included within the term dispute, they're not subject to mandatory non-binding arbitration. They're subject to pre-suit mediation. And then if not resolved at mediation, then it's followed by litigation. If you're not overly familiar with dispute resolution in condominium associations, Florida statutes requires that certain disputes, as they're defined by statute, either go to pre-suit mediation or mandatory non-binding arbitration before you can file a lawsuit in court. So this is expanding the definition of what will constitute a dispute as of July 1st of 2027. All right, so we're moving along pretty quickly, I think. Topic 2 is a mashup of some really important information regarding elections, official records. We do talk about websites in here as well. So elections, do we need an election? If you're having a vacancy on your board that's caused by the expiration of a director's term, then it's filled by an election. If there is a vacancy on the board that's caused before the expiration of the term, except by recall, because recall is its own thing, then the vacancy is going to be filled either by a majority of the remaining directors, or the board can choose to hold an election to fill that vacancy. Now, the election timeline, just remember 60, 40, 35, 14. That is your general timeline. Not less than 60 days before an election, you have to send out your first notice of the date of the election. That first notice lets everyone know, hey, your nominations period is open. Go ahead and send us your written notice of intent to run for the board, not less than 40 days before that scheduled election. Then the candidate has the ability to provide a candidate information sheet not less than 35 days before the election. Now, that candidate information sheet can be no larger than one side of an 8.5 by 11 sheet of paper. And then the association, once it's timely received, will be responsible for reproducing the candidate information sheet and then sending it off to all of the owners once it's within this, once they get ready for the second notice. Now, that second notice has to be sent to the members not more than 34 days. Obviously, that's because you have to provide enough time for them for candidates to send in their candidate information sheet if they want to, and not less than 14 days before the annual meeting. Now, that second notice is going to be sent with the candidate information sheets, the ballot, inner envelopes, outer envelopes, and we'll discuss the election process, but that's what you need to send with that second notice. And of course, this is assuming that you have enough candidates to hold an election. There could be an election by acclamation. We'll discuss that next. Unless otherwise provided in your governing documents, the board will consist of 5 members, except if the condominium has 5 or fewer units, then it has to be at least 3 members. If the articles or the bylaws permit directors to serve terms of longer than 1 year, then the terms will expire at the annual meeting, unless the condominium is timeshare or non-residential condominium. Theirs is really going to be governing document based. Or if there's a staggered term, and the board's term doesn't expire until a later annual meeting. And your term is not going to expire unless there are no other candidates. There's going to be a rollover situation happening there. A director cannot serve more than 8 consecutive years unless approved by 2/3 of all votes cast in the election, or unless there are not enough candidates to fill vacancies on the board. And the only board service that is used to calculate this 8 consecutive years is board service occurring on or after July 1st of 2018. That's when this particular term limitation was put in place. That's going to be your benchmark for calculating that 8 years. Now, if you're in a residential condominium of more than 10 units, co-owners of the units cannot serve as directors at the same time unless they own more than 1 unit, or unless there's not enough eligible candidates to fill vacancies on the board. Mind you, this is not serve on the board. That doesn't mean that you guys can't run for seats on the board, and maybe you get elected, but your co-owner does not. That's okay. It's just service on the board that would be of issue. Like I mentioned before, election by acclamation, if the number of vacancies equals or exceeds the number of candidates, then you're not going to be having an election. Those candidates would be seated on the board at the annual meeting. And in that case, you wouldn't be creating a ballot or sending a ballot, sending envelopes, because you wouldn't have any ballot tallying done at the annual meeting. There's no quorum requirement to hold a valid election. However, at least 20% of the eligible voters must cast a ballot. Elections are decided by a plurality of the ballots cast, meaning if there are 5 candidates and there are 3 vacancies and you have 1 vote per unit, you can vote once for each of the 3 vacancies. So Johnny, Sally, and Michael, you can vote for all 3 of those, notwithstanding that your unit is only allocated 1 vote. Ballots, sign-in sheets, voting proxies, any papers relating to unit owner voting has to be maintained with the association's official records for a period of 1 year from the date of that vote or until the next election if the election is later. And any challenge to the election process has to be commenced within 60 days after the election results are announced. After that 60-day period happens, then that person is looking at a recall and not an election challenge. So candidate is any eligible person who has timely submitted written notice of their intent to become a candidate for the board. Any person desiring to be a candidate for the board does have to be eligible upon the date of the deadline for submitting their notice of intent to run, which again is that 40-day mark before the annual meeting, in order to have their name on the ballot and to serve on the board. If that person is delinquent in the payment of any assessment due to the association as of the deadline, then they're ineligible to run for the board. And any person who has been suspended or removed by the division under the Condominium Act is also not eligible to be a candidate. Now, it's interesting to note that a board cannot create a committee for the purpose of nominating candidates for the election. You can create a committee to go and encourage qualified people to become candidates for the board, but this is really a self-nomination process. So you can't have a committee that's doing the nominations for people here. A person who's been convicted of a felony or who's been convicted of an offense in another state, which would be a felony here in Florida, is not eligible for board membership unless their civil rights, being the right to vote, right to hold public office, serve on a jury, what have you, have been restored for at least 5 years as of the date that the person seeks election to the board. Now, if that person gets on the board and it's later determined that the person was ineligible for this reason, it does not affect the validity of action by the board. If there's a criminal charge pending against an officer or director for such as forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, then that person cannot be appointed or elected to a position as an officer or director of any association and cannot have access to the official records of any association unless there's a court order. Now, you heard me say that there's going to be envelopes that get sent with the second notice if there is going to be an election at the annual meeting. This is because we're voting by a secret ballot. Proxies, whether they be limited or general, cannot be used in the election. You're going to have an election ballot. You complete your election ballot. You put it into an inner envelope that has no markings on it to say, oh, this is so-and-so's ballot. That inner envelope gets sealed, gets put into an outer envelope. Now, the outer envelope has to include the name of the voter, the unit number or numbers that are being voted on, and have a signature space for the voter to sign. That inner envelope can only contain 1 ballot if there's someone who owns multiple units and is able to vote for those units. You would have to use that person would have to use multiple inner envelopes for each ballot. Reason being is because you don't want to open up an inner ballot envelope and see, oh, it's got all 3 of the units owned by Johnny G. And then you'll know, okay, these are Johnny G's votes. We're trying to keep the secrecy of the ballot. The voter does have to sign that exterior envelope in the space provided, and then mail or hand deliver the ballot envelope to the association. Once the association receives the ballot cannot be rescinded or changed. The unit owner cannot authorize another person to vote their ballot, and if the ballot is improperly cast, then it's invalid. A unit owner who violates this provision can be fined by the association. However, there are instances in which an owner can get assistance for casting their ballot. If they're blind, disabled, or illiterate, then they can obtain assistance for casting their ballot. Once the association has those ballot envelopes with the information on the outside, the association will need to verify the information on the outer envelopes. Now, this can be done either on the morning of the annual meeting or at the annual meeting itself. And it's done by an impartial committee. The impartial committee consists of members who are not current board members, officers, candidates for the board, or any of their spouses. If you are doing this at a meeting held prior to the annual meeting, that meeting has to be held on the same date as the annual meeting, has to be open to all members, noticed like a board meeting, which is a 48-hour notice conspicuously posted on the condominium property. The verification of the information includes checking the signature, making sure that it is signed, looking at the unit identification on the outer envelope, and then cross-checking that with a list of the qualified voters. Once you have verified the information, you check them off on the list as having voted. If the outer envelope is not signed by the eligible voter, then that vote, that ballot, is marked disregarded or with words of similar import, and the ballot that's in that envelope is not counted. That doesn't mean you throw it away. You do still have to keep it with the election materials, with the association's official records, but it does not get tallied. A person who engages in a fraudulent voting activity related to an election that's using threats, bribery, or intimidation related to voting or casting a ballot commits a first-degree misdemeanor. Yeah, we're talking crimes here. Forgery of a ballot envelope or voting certificate used in a condominium association election is punishable as a third-degree felony. That's a serious crime, felony crime. Electronic voting. I don't know how many associations are really taking advantage of the electronic voting system, but it is for larger associations. It's great because you get those results like instantaneously. An association can use an online voting system for owner votes if the owner consents, either electronically or in writing, to participate in online voting, and that consent is valid until the owner then opts out of online voting. Once the owner votes electronically through the online voting system, they are counted as being in attendance for the purposes of determining a quorum. And the use of electronic voting is established by board resolution at a board meeting that's noticed at least 14 days before the meeting by mail, delivery, electronic transmission. Again, you can only use electronic transmission if the owner has provided written consent to receive email notice or facsimile notice. And the notice has to be posted on the condominium property, evidenced by an affidavit. So it's noticed essentially in the same manner as a membership meeting. That board resolution has to provide that owners will receive notice of the opportunity to vote through an online voting system, establish reasonable procedures and deadlines for owners to provide their written consent, and establish reasonable procedures and deadlines for owners to opt out of online voting. Because remember, that written consent is going to be good for so long as it remains unopted out of. If online voting is used, the association has to provide each owner with a method to authenticate their identity, to ensure the secrecy and integrity of the election ballot, and to confirm at least 14 days before the voting deadline that their device can successfully communicate with that online voting system. The online voting system has to be able to authenticate the identities, separate information, identifying information from the vote, transmit a receipt to the owner, store and keep electronic votes accessible to election officials for recount, inspection, and review purposes. There are lots of services out there that will comply with these requirements. A couple of the names that come to mind are Vote HOA Now, Get Quorum, and they all will provide you with assistance in establishing the electronic voting. If the board authorizes the online voting by way of that resolution, The first notice of the date of the election must disclose the procedure and deadline to consent to electronic voting. And the board must honor a unit owner's request to vote electronically at all subsequent elections unless the owner opts out of online voting. A vote of the unit owners cannot be taken on any issue other than those specifically identified in that electronic ballot if the quorum is based upon unit owners voting electronically. Reason being is because you're presenting a question to the members who are in-person attendance, but those who voted electronically don't have the opportunity to participate. So we've discussed our board, and we've got our people on our board. So what about our officers? Unless otherwise provided in the bylaws, a board must have a president, secretary, and a treasurer who perform the duties of such offices that are usually performed by officers of corporation. Again, unless prohibited in the bylaws, the board can appoint other officers and grant them duties as it deems appropriate. I've seen a lot of governing documents that provide for assistant secretary or assistant treasurers or multiple vice presidents. Officers serve without compensation and at the pleasure of the board unless it's otherwise provided in the bylaws. And typically officers are selected by the board immediately following the election of the directors at a meeting that's called the organizational meeting of the board. Directors cannot vote by proxy or by secret ballot. However, they can use secret ballots when voting for officers. And there's no prohibition against changing officers midterm. This is typically done just by the board vote at a board meeting. You can change your officers. Disqualification from service. Now, an officer or director who knowingly solicits, offers to accept, or accepts a kickback commits a third-degree felony and is subject to a civil penalty. Again, penalties, we're talking money, and must be removed from office and a vacancy declared. Now, a kickback is anything or service of value for which consideration's not been paid for the person's own benefit or the benefit of their immediate family from any person providing or proposing to provide goods or services to the association. An officer or director charged by information or indictment for any crime that's outlined in this particular Florida statute, including forgery of a ballot, theft or embezzlement of association funds, or obstruction of justice, is removed from office. If those charges are resolved without a finding of guilt, well, then that officer or director must be reinstated for the remainder of the term, if there's any remaining term left. A director or officer more than 90 days delinquent and in the payment of any monetary obligation due to the association is deemed to have abandoned their office, creating a vacancy, which is then filled according to law. Now, what's interesting to note here is that for candidacy, to determine eligibility for candidacy, it's a delinquency in any assessment that's due to the association. If you're delinquent in any assessment due to the association as of the last date that you can nominate yourself to run for the board, you're not eligible to run. Well, here it's more than 90 days delinquent in the payment of any monetary obligation due to the association, and that can include a fine. So there is a distinction between the two, and it never used to be that way. They used to be the same, but then they changed the eligibility requirement several years back. A director who knowingly and willfully violates the official records inspection requirements 2 or more times within a 12-month period, that's what's considered repeatedly, 2 or more times within a 12-month period, commits a second-degree misdemeanor and must be removed from office and a vacancy declared. A person who knowingly or intentionally defaces or destroys accounting records that are required to be maintained by the association, or who knowingly or intentionally fails to create or maintain accounting records with the intent of causing harm to the association or any of its members, commits a first-degree misdemeanor and is personally subject to a civil penalty and must be removed from office and a vacancy declared. A person who willfully and knowingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment for the commission of a crime or to attest to another person assist another person with such avoidance or escape commits a third-degree felony and must be removed from office and a vacancy declared. So there were a lot of crimes and criminal penalties and personal civil penalties created within the past few years for service on the board. A person who uses a debit card issued in the name of the association or that's billed to the association for any expense that's not a lawful obligation of the association commits theft and is also removed from office and a vacancy declared. Now, a lawful obligation of the association is one that has been properly pre-approved by the board and is reflected in the board meeting minutes or in the written budget. If the board finds that an officer or director has violated the conflict of interest requirements, and the conflict of interest requirements will be discussed by Alan a little later, but it's basically a disclosure and a particular vote requirement. The officer or director is deemed removed from the office and a vacancy is created to be filled according to law. Now, a director who fails to timely file the written certification and educational certificate, which you guys will get at the end of this presentation, you fill out your evaluation. Several days later, you will get your certificate, is suspended from service on the board until he or she complies with the requirement. However, the failure to have the written educational certificate on file does not affect the validity of any board action. Now, note here that it is not just the educational certificate that you need to do, but also the written certification. There used to be an option. You can be certified by written certification or an educational certificate, but that was changed at the same time that they made this course a 4-hour-long course with the different topics to be discussed. So now you'd have to have both the written certification and the educational certificate. The written certification is a form that the division has on their website. You can go there and plug in the information there. As far as the website requirements go, associations having 150 or more units have to have a website. This is not a new requirement. This is something that's been around for a little bit now. However, coming January 1st of 2026, this is going to apply to any association having 25 or more units. So if your association has 25 or more units and does not already have a website, you guys need to gear up because these are coming and there are a lot of official records that have to be posted on your website. The association's website has to be an independent website or web portal that's wholly owned and operated by the association, or it could be through a third-party service provider. The association's website has to be accessible through the internet, has to contain a subpage or web portal that's protected by username and password that is only accessible to unit owners. The unit owner can make a written request and the association will then have to generate a username and password so that they can access those protected portions of the website. Now, as far as what documents, have to be posted on the website, like I said, it's a long list. The recorded declaration of condominiums, bylaws, amendments to those, articles of incorporation, rules of the association. Obviously, your governing documents need to be on there. A list of all executory contracts or documents with the association as a party, or if the association has obligations under those contracts. And after bidding for the related materials, equipment or servicing has closed, a list of those bids received by the association within the past year. Summaries of the bids for materials, equipment, or services that exceed $500 have to be maintained on the website or the application for 1 year. And in lieu of summaries, you can post the complete copies of the bids. You have to post the annual budget, any proposed budget that may be considered at the annual meeting, the financial report, any proposed financial report to be considered at a meeting, director certifications, all contracts and transactions between the association, any director, officer, corporation firm, any contract or document regarding a conflict of interest or possible conflict, board meeting notices with the agenda and any document required for the meeting. For example, if you're going to be approving a contract, you need to be posting that contract as well. The notice of any unit owner meeting has to be posted no later than 14 days before the meeting. And this has to be posted in plain view on the front page of the website or on a separate subpage labeled notices that's conspicuously visible on that landing page, that front page. The association also has to post any document to be considered and voted at by the owners during the meeting, or any document that's listed on the agenda at least 7 days before the meeting. I'm not sure why there is not congruity there, but 7 days. But that's the requirement. So for example, if they're going to be voting on an amendment to your governing documents, you would be posting that amendment as well. The most recent structural integrity reserve study, as well as all inspection reports, have to be posted like we discussed at the beginning of the presentation. Copies of all building permits that were issued for ongoing or planned construction. All of those documents need to be posted on the association's website. Now, the failure to post these documents on the website does not in and of itself invalidate any action or decision of the association, but it is still a requirement to do the posting. Each association has to designate on its website a person or an entity and their contact information who receives the estoppel certificate request. And estoppel certificates will be discussed later in the presentation with Alan. The association must ensure that the information and records that are not accessible to unit owners are not posted on the association's website. Now, what are those records? We will discuss that in the next portion. If protected information or information that's restricted from being accessed by unit owners is included in documents that are required to be posted, then the association has to redact that information before posting it on the website. However, if in complying with the posting requirement, there's no liability for disclosing information that's protected or restricted unless it was made with the disclosure was made with a knowing or an intentional disregard of the protected or restricted nature of such information. So inadvertent disclosure isn't going to necessarily attach liability. Instead of posting the required documents on a website, the association can get an app. And the downloadable app must meet all the same requirements that are imposed for websites. Now, as to our official records, the official records are comprised of any written record that relating to the association, essentially. Plans, permits, warranties that were provided by the developer, the governing documents, meaning the declaration, bylaws, amendments, articles of incorporation, current rules, your meeting minutes, a roster of all the unit owners, including their mailing addresses, unit identifications, voting certificates if you require a voting certificate, and if known, the telephone numbers. The association must also maintain and make available for inspection the email addresses of those owners who either consented to receive notice of association meetings via email or expressly indicate that the email can be shared with other owners. Emails may only be used for the business operation of the association, and the association cannot sell or share the email addresses with outside parties. A copy of all the current insurance policies, financial records, accounting records, those all make up your official records, management agreements, bill of sale for transfer of all real personal property owned by the association, also whatever deeds for association property that they might own in their own name, ballots, sign-in sheets, proxies, anything relating to unit owner voting, rental records if the association acts as a rental agent for the units, a copy of the current question and answer sheet. Now, I get so many board members who don't know what the question and answer sheet is. You are required to have one, and you're required to update it every year. The form is provided by the division. And let me see, I know I did this last time. Let me see if I can share it.
Hey, Danielle, we'll have the link for that website where that can be found after the folks fill out the evaluation.
Oh,
It'll be on the confirmation screen. So save you some time there.
gotcha. Okay, well then I'll go back to this then. Oy vey. Let me get back to the slide that I was on. Here we go. From current slide.
And folks, while Danielle's doing that, I see a couple of people asking, hey, do you see my question? Remember, questions will be done at the end of each attorney's presentation. We're not going to do all of them. We'll get to a few of them. And you'll see Courtney and I answering some questions, but the ones we are answering do not require an attorney's answer. So that's why some are being answered and some are not at this point. Danielle, back to you.
Okay, so the question and answer sheet, you'll get a link to it. It is important that you fill that out and update it annually. A copy of all of your inspection reports, again, like your milestone inspection, structural integrity reserve setting inspection, bids for materials, equipment, services, affirmative acknowledgements. That's something that will be discussed in Alan's portion, having to do with invoicing for assessments, things like that. Copy of all building permits, board member educational certificates, and like I said before, all written records relating to the operation of the association are going to be official records that have to be maintained by the association. Now, official records have to be maintained at least for 7 years. Mind you, this is a minimum retention period, not a maximum. So that doesn't mean that after 7 years go by, you can just throw them away. This is a minimum, not a maximum. However, there are certain exceptions to this 7-year requirement. The plans, permits, warranties, items provided by the developer, your declaration, bylaws, amendments to those, articles, amendments to those, copy of the current rules and all meeting minutes, those have to be maintained forever. The CEUs and the inspection reports have to be maintained for 15 years, as we discussed before. Bids for work to be performed or materials or equipment services must be maintained for at least 1 year after receipt of the bid. And ballots, sign-in sheets, voting proxies, any voting material has to be maintained for 1 year from the date of the vote, or again, if there are staggered terms, then until the date of the next election. Now, here's a biggie too. The official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. Yes, so your official records do need to be organized. If the official records were lost, destroyed, or otherwise unavailable, the obligation to maintain the official records includes a good faith obligation to obtain and recover those records as is reasonably possible. Now, what does this mean exactly? A good faith obligation? It's not clear. This is a new statute. And, I think you use whatever's commercially reasonable. You don't need to be spending a fortune to try to find official records. You have to weigh the options and act reasonably. The inspection and copying of the official records. So once the association receives written request, the official records have to be made available to an owner and the owner's authorized representative within 10 business days and within 45 miles of the condominium or within the same county. Renters do have a right to inspect and copy official records, but it's only as to the declaration of condominium, bylaws, rules, and the inspection reports. The association can comply with the inspection requirements by having a copy of the official records available for inspection or copying at the condominium property, offering the option to make the records available electronically on the internet. And if they're posted on the association's website, then the association can fulfill its obligation by directing the owner to the website. Won't that be great for all of our associations to simply say, hey, they're on the website, go to the website. Allowing the records to be viewed in electronic format on a computer screen and printed upon request. Maybe you have a computer within your manager's office where they can look at their records electronically. The right to inspect the records includes the right to make or get copies at the reasonable expense of the member. The association does have to allow the member or their authorized representative to bring in a portable device like their phone or a scanner, free of charge to make their own copies. And yes, I have been to official records inspections before where someone did bring a full-on printer copier, plugged it in, and made their own copies that way. So, and we had to let him do that. The association has to maintain an adequate number of copies of the governing documents of the association. The question and answer sheet, again, you need to make sure that you have that, and the year-end financial information on the condominium property to make sure that they're available to owners and to prospective purchasers. Now, the association can certainly charge its actual costs for preparing and furnishing those documents to those who are requesting them. New law that's effective July 1st of 2024, so it was in the recent legislative session. In response to a written request to inspect the records, the association has to provide a checklist of all records that were made available for inspection and copying. The checklist has to identify any of the association's official records that were not made available to the requester. The association has to maintain the checklist for 7 years. And the association delivering a checklist creates a rebuttable presumption that the association has complied with its obligations. The association may and absolutely should adopt rules regarding the frequency, time, location, notice, and manner of record inspections and copying. However, the association cannot require that the owners show any proper purpose for the inspection or state any reason for the inspection. That's their business, not the association's. As I mentioned before, there are certain official records that are not accessible to the members. Even though they're not accessible to the members, you do still need to maintain them as official records of the association. These are records protected by the attorney-client privilege, the work product privilege, information obtained by the association in connection with the approval of the sale, lease, or transfer of a unit if your governing documents authorize the screening and approval of purchasers, tenants, occupants, whatever documents that you use in that process. They are official records, but not accessible to the members. Personnel records of the association or its management employees. Now, personnel records does not include employment agreements with an association employee or the management company or budgetary or financial records that indicate their compensation. Medical records of unit owners, and you might be thinking to yourself, when would I have a medical record of a unit owner? Well, assistance animals is the number one reason there why you might have some medical records of unit owners. Electronic security measures that are used by the association to safeguard data, and software and operating systems that are used by the association, which allow the manipulation of data, like Word, Microsoft Word, even if the owner owns a copy of the same software that's used by the association. Affirmative acknowledgements, again, Alan will discuss that in the second portion of the presentation. And personal identifying information, social security numbers, driver license numbers, credit card numbers, email addresses, telephone numbers, fax numbers, emergency contact information, addresses of a unit owner, other than as provided to fulfill the association's notice requirements. So if they provided it to fulfill the association's notice requirements, it's fair game. If they haven't, though, it needs to be redacted or something, or just not made accessible to the owners at all. Excuse me. Other personal identifying information of any person is not accessible except the name, unit designation, mailing address, property address, and any address that's used to fulfill the association's notice requirements. Now, that having been said, the association can create a owner directory that contains the name, unit address, and all telephone numbers of each unit owner. However, the owner can have their telephone numbers excluded by written request to the association. And the association is not going to be liable for inadvertent disclosure of this information if the information is included on an official record of the association and is voluntarily provided by the owner and it's not requested by the association. In that instance, then it's also, the association's liability is not going to attach if the association happens to disclose it in that manner. An owner can consent in writing to the disclosure of any contact information that's not otherwise accessible but to unit owners. Website postings. The association, again, has to ensure that whatever information is not accessible to the unit owners is not posted on the website. And if it's included within a document that has to be posted, then it has to be redacted. The association is not going to be liable for disclosing protected or inaccessible information unless that disclosure was made with a knowing or an intentional disregard for the classified nature of that information. And the association is not responsible for the misuse or the use of information provided to a member or the representative in complying with the inspection and copying requirements unless the association has an affirmative duty not to disclose such information under the Condominium Act. This is just explaining a little bit of what that attorney-client privilege is. Essentially, any correspondence from the association's lawyer is going to remain privileged unless the board votes to waive the privilege. Now, it's only the board that can vote to waive the privilege. I don't hold the privilege as the attorney. The client holds the privilege. And so I can't disclose anything to anyone unless the board has voted to disclose that attorney-client privilege. Now, let's say the association gets that written consent, or I'm sorry, that written request to access and inspect and copy the official records, but fails to respond within that 10 business day time period. Well, in that case, a rebuttable presumption is made that the association willfully failed to comply with the requirements of the Condominium Act. A unit owner who is denied that access is entitled to actual damages or minimum damages, and minimum damages are $50 per day for up to 10 days, beginning on the 10th working day. The failure to permit inspection entitles any person prevailing in an enforcement action to an award for attorney's fees from the person who was in control of the records, or who directly or indirectly knowingly denied access to those records. A director or manager who knowingly, willfully, and there's that word again repeatedly, meaning 2 or more violations in a 12-month period, fails to provide access to the official records, commits a second-degree misdemeanor, and is removed from office. The refusal to allow inspection or copying of an official record that is accessible to the members within the specified time periods in furtherance of a crime is punishable as tampering with physical evidence or as obstruction of justice. And there are some other official record offenses for defacing or destroying accounting records that are required to be maintained. We talked about this earlier when we discussed disqualification from the board. Same thing with the failure to release or otherwise records to escape detection or arrest, trial, or to help someone else do that. Third-degree felony must be removed from office. The destruction of an official record in furtherance of any crime is punishable as tampering with physical evidence or as obstruction of justice. An outgoing board or committee member has to relinquish whatever official records may be in their possession or their control to the incoming board within 5 days after the election. And whoever willfully and knowingly fails to do so is subject to a civil penalty imposed by the division. All right, so, I feel like I sped through that.
That was great. No, that was great. That was fantastic. And what I'm about to say now, I think everyone's going to appreciate. Alan will be on for the second half at 1:45 Eastern. Okay. So what we're going to do is, Danielle, while you're looking over some of the questions to answer, if they're timely and if they're on topic, you can go ahead and look through those. So folks, what we're going to do is we're going to answer some of the Q&A now. Danielle is, and then after that, if we finish all the Q&A by 1:45 or sooner, just you can go ahead and take a bio break, get a drink, get a quick bite, and come on back. And even if Alan, he just texted me. Okay, so we'll get started again at 1:45. So Danielle, if you have some of the questions that you'd like to answer, and if they're on
Sure.
topic, you can do that, and then I'll go over the evaluation process and how everybody can get the slides and the video before we reconvene at 1:45.
Okay, so someone is asking about the ability to waive and reduce reserves. I guess they thought that that was no longer available. So that's not available for your structural integrity reserve study items. However, for those traditional reserves, you can still vote to waive or reduce those reserves. It's just the SERS reserves are now sacrosanct. And again, that's, roof, fireproofing systems, or fire safety systems, windows and doors if maintained by the association, waterproofing, anything with a replacement or deferred maintenance value of greater than $10,000 if the failure to do that replacement or deferred maintenance would impact the structure of the condominium building. Do we recommend reserves on less than 3-story condos regardless of legal requirements? So this is interesting because it says here, can a board vote in full reserves without putting it to a vote of the unit owners? Now, the requirement under Florida law for the board's budget is to adopt it with fully funded reserves. The board does not get the option to adopt a budget with less than fully funded reserves. That's a determination that's made by the unit owners. So the board can determine whether or not to present the unit owners with the option to waive or reduce reserves. If the vote is not put forth by the board to the membership, or the members don't successfully petition to hold a membership meeting to vote to waive or reduce reserves, and that vote is successfully done, well then reserves will remain fully funded in the budget as adopted by the board. Kaufman language. Oh, somebody's asking about Kaufman language. Okay, so Kaufman language is that magical phrase as amended from time to time. And when it's used with reference to the Florida statutes, namely the Condominium Act being Chapter 718 Florida statutes, when it's used in your governing documents, that as amended from time to time Kaufman language will magically make your declaration update to all of the changes that are made by the Florida legislature to that particular act. Now, that's without regard to whether or not the change is advantageous to the association or not. And it includes both the substantive changes, meaning changes of vested rights, and procedural changes. Now, without Kaufman language, we have to undergo a different analysis. If there's no Kaufman language, well, then we have to say, is the statutory change procedural, meaning how we get things done? Then it's still going to apply to your association. Is it a clarification of existing law? If so, then it'll apply to your association. Is it as a matter of public policy? If it's a public policy issue, still going to apply to your association. And typically anything that's remedial in nature will still apply to your association. So that's what Kaufman language is. It's as amended from time to time, and it determines whether or not the substantive changes to legislation applies to your association. Let me see here. Okay, what happens if there are no volunteers for the board? An owner can petition the court for receivership, and then your association goes into receivership, which is very expensive. I don't know what someone's asking if we use building link, if that covers the website requirement. I don't know building link in particular. It might, if it's considered like that third party, website and checks off all of those things. If it meets the website requirements pursuant to statute, then yeah, but I don't know building link specifically.
You just got to make sure that they're a third party vendor, supplier, provider. You just got to make sure that you have all those documents. Should you ever stop working with another organization, you want to make sure you have everything you need for another website if it's not simply just handed over to you.
Yeah, it's a private site where everybody has individual logins.
Okay. Jeffrey Glenn is asking a question about officers serving in more than one capacity, a person serving in more than one office. So this is typically permitted. If it's prohibited, it'll be prohibited in your governing documents, most likely in your articles of incorporation or your bylaws. You're going to want to look at those governing documents to see what they say. But generally speaking, yes, it's permitted for one person to serve in more than one office. Zoom, can a secretary deliberately delete Zoom meeting links and minutes from the website?
Refuse to
The
post the
Zoom,
link. Yeah.
the link, if it's part of the notice, the notice needs to be posted. And they can't delete the notice. If it's like I don't know, posted somewhere else on the website, I can imagine that they can probably remove the Zoom meeting link if, just to not confuse people, to say, oh, here's the Zoom meeting link, and then click on the wrong thing in order to join the Zoom meeting. But it depends how it's being posted. Minutes, certainly, if you're required to post minutes, meaning if your association's required to have a website, you're required to post minutes, and you can't be deleting minutes from the website. Someone's asking about banking requirements, probably for lenders. I don't know what the current going percentage of having reserves are. And certainly the requirement's going to be different if it's like a Fannie Mae or Freddie Mac backed a mortgage. If all of your governing documents are available on the website, does the association or management company have any further obligation regarding document requests other than referring the requesting owner to the website? So if for some reason all of your governing documents are available on the website, which I doubt, because not everything is required to be posted on the website, then certainly pointing the person to the association's website would comply with the official records requirement. However, emails could be part of the official records. And I wouldn't imagine that your emails, every time you're generating emails or sending emails, you're posting them to the website as well. So I would be very careful about having that as your only response to an official records request. It depends on what's being requested.
Good answer.
Can any owner request an update the condo document for their condo association? I think what you mean to ask here is whether or not the owners can amend the declaration of condominium. And I guess technically the answer to that is yes, because the owners do have the ability to petition to hold a special meeting of the members. And if the members prepare an amendment that meets the statutory requirements for amending the governing documents, and then petition to hold the special meeting, and then actually get the amendment approved, and the only approval that's required to amend your documents is membership approval, because some of them do require board approval as well. Then presumably, yeah, you could get it done. It would be very difficult to do, but it's not impossible. Again, this is entirely based upon your governing documents and how they get amended, be it by membership approval alone or by both board and member approval. Because if you have a board approval and it's something that the board doesn't want to do, you're not going to get it approved and it won't be able to be recorded.
Remember, folks, while Danielle's looking to see if there's any other pertinent questions here, we'll get started again at 1:45 Eastern time. So you're encouraged to stay for the Q&A, but this part is not the required material. So you can take a break now. Now's the time to take a break if you want to take a quick break. 1:45, Alan will be on to get started with the next set of topics. Let's see here.
Let me go back up to the top because maybe.
Yeah, there might be a couple at the top. Let's see here.
Okay, what if the board of directors is not following the reserve study for a condo that is a 2-floor building? Is there anything other board members can do? So the reserve study, I forget if it has to be, how often it has to be redone for our regular reserves. But they should not be reserving for less, though they could reserve for more. And if there's anything that the board members can do, well, presumably the other board members create a minority of your board. So it's not like you guys can simply do a runaround and adopt a budget with properly funded reserves if they're reserving less than what's required by the reserve study. I think at that point, you'd probably be acting as a unit owner and trying to seek redress from the division. What are the requirements for a phase 1 milestone inspection if no phase 2 is required? Phase 1 recommendations, that is, I think maybe the question got sent before she was able to finish typing. So the phase 1 milestone inspection, the requirements for it, I mean, it's the phase 1 milestone inspection is a visual inspection of the property and its structural members and structural systems. Again, that's the masonry walls, the roof, the foundation, whatever steel beams, wood beams, whatever you have, concrete framing, would be part of that visual inspection. So I'm not sure what else you mean by requirements. If you are required to have one, i.e. you are a residential condominium, 3 stories or more in height and 30 years of age, or potentially 25 years of age, depending upon your local conditions and what your local building official will require, you will be provided with a notice from your building official to say you need to have a milestone inspection completed. Once you get that, then you're going to notify your owners within 14 days that you have to have that milestone inspection done, and the deadline for having that milestone inspection completed. And then you would be contacting an engineer or an architect to complete that phase 1 inspection for you. And they will know what the requirements for completing that inspection are. Like I said, the Florida Commission has already adopted Chapter 18 to the Florida Building Code that has the minimum requirements for the milestone inspections. So they will know what is required to be put into the phase 1 milestone inspection. And if there's any substantial structural deterioration detected during the phase 1, that will determine whether or not a phase 2 is required.
And Caroline, where it looked like the question was complete, if you scroll all the way to the bottom, Danielle, she clarified what may have been missing.
Oh, okay. Let me see.
At 12 timestamp at 12:36 for me, probably 1:36 for you. I'm in the central time zone. I'm in the panhandle time zone.
Okay, so if there are phase one repairs, yeah, you're gonna have to do them. And your local building official may have timing requirements to actually do those things. But generally speaking, you do have to complete those. And again, you're gonna lean on your engineer, lean on your architect. They're the ones who are the experts in this particular field. They'll be able to tell you what needs to be done and when and what the compliance requirements are based upon local codes for that are within your jurisdiction. Okay, Gloria's asking about buyers who want to see minutes in preparation of a purchase and want info on future assessments or past issues. So buyers are not entitled to inspect and copy the association's official records. Essentially, they'll be able to get the governing documents of the association, that question and answer sheet, copy of the structural integrity reserve study, milestone inspection report. But they're not going to be able to dig through the association's official records before they make their purchase. If it's having to do with the assessments and what future assessments might be, well, they'll see that on the estoppel certificate. And like I said, Alan will be discussing the estoppel requirements in his portion of the presentation. As far as leaks or bugs, I mean, that's going to be a unit inspection type issue. Can the secretary who developed by himself refuse to? I'm not sure what that question is.
He meant with the website. He said, can the secretary who developed the website by himself?
Oh, I see. The secretary developed the website and is potentially refusing to hand over the website if he or she doesn't want to do it anymore. What can the association do?
If they're not turning over you mean the control of the website?
Control of the website.
Like the
They made
admin control?
Yeah. Yeah. That's kind of earlier we were talking about website or not, you should have the record somewhere else so that if you need to create another website, you have everything, right? I mean, that's about all you can really do is make sure you have everything you need, right?
Yeah. And there is the requirement that if they're outgoing, then they do have to turn over whatever official records they have in their possession or that are within their control. And the failure to do that may result in penalties. So perhaps go to seek redress from the division against that particular person. That would be the least expensive route. Let me see.
Folks, we're 5 minutes away from the next part. Alan will be on momentarily. Danielle, do one more and then I'll go over the evaluation.
Berkowitz asks, are those fines on individual board members or on the association? I think he's talking about the civil penalties. For example, if someone forges a ballot or something like that, those civil penalties are against the person, not against the association. So
which question was that? Was that
Seth Berkowitz? It's at the very top of my list.
Okay.
Are those fines on individual board members or on the association? Okay. And again, I think he's talking about the penalties, civil penalties, and those are against the person.
Okay.
Does 10,000 K bullet H apply to elements A through G in the statute only, meaning only to structural integrity and safety building? That's fine. So that $10,000 item at the very end is separate and apart from any of the other things that are listed. That's an additional item. That 10,000 mark does not apply to any of the things higher up in that list. It's in addition. It's like a catch-all, anything that's got $10,000 or more in replacement or deferred maintenance, that would affect the structure of the building if not completed, then it would be part of your structural integrity reserve study. That's next question is a little confusing to me, having to do with board members.
Where are you at?
He's asking about having 5 members
Oh.
or you know, the number of board members that you have is going to be based on your governing documents. If your governing documents don't provide a number, then the statutory gap filler is 5 members. Unless you have 5 or fewer units, then you have to have at least 3 members, but really your governing documents can provide however many number of board members. So it's really governing document based, as to how many board members you can have. But the years of service, like I said before, is calculated from that July 1st, 2018 date forward. You wouldn't use a director term of service occurring prior to July 1st of 2018 to calculate that 8 consecutive year term limitation. And again, that 8 consecutive year term limitation is only going to be applicable if there are more than enough candidates, and if they don't get that 2/3 vote, because you can go beyond the 8 consecutive years if there aren't enough eligible candidates, or if they're voted in by 2/3 vote. Beth is asking another question about 1 or 2 board members to make the decision to present the option to reduce reserves or not. Decisions by the board need to be made by the board, and board decisions are made at a properly noticed board meeting. And I will leave it at that.
All right. Danielle, thank you. It's a lot of speaking. It's a lot of consecutive speaking to have to do.
I know, and for whatever reason, my motor mouth was not working this morning. Kept tripping over my own words. Hey, Alan.
Hi.
Well, before you head out, one last time, Danielle, how can folks reach you? The best way to reach you and your Palm Beach location.
All right, so I'm here in Palm Beach Gardens. You can give us a call, 561-241-4462. You can email me. I am dbrennan@kbrlegal.com. You can, of course, check out all the information about all of our attorneys on kbrlegal.com. Also, check out our calendar of events. And as I said before, I will be at the Palm Beach Expo, the L&L Expo next week. So if you want to come visit me and say hi, I will be there.
Wonderful.
Thank you so much.
Thank you, guys. Thanks for having me. And you guys have fun with Alan. Until next time.
Bye.
Take care. Ciao for
Bye.
now. Bye-bye. And folks, once again, for those of you who may have joined a little bit later at the beginning and didn't hear me say, if you haven't pressed the chat button on your Zoom interface, please do that now. That is not to be confused with the Q&A. Hit the chat button just so it appears. It'll likely say for you chat is disabled, but that is where we're going to place the link for the evaluation a little bit later. And once Alan finishes his portion, the required portion, that's when we're going to place the link to the evaluation in the chat. You'll need to click on that link and fill out the evaluation. We will then cross-check that with the official Zoom attendance list to make sure you were here the entire time. And folks who were here the entire time will receive an email with their certificates. If you phoned in, we'll match up the phone number with your registration to make sure that was you. We'll send everything over to you as well as a link to the evaluation because we know you cannot see the chat area if you were phoning in right now. So we've got you covered that way as well. Courtney, I'm going to turn it back over to you to do another wonderful instructor introduction.
Hi, thank you so much, Jeff. So today we have Alan Schwartzseid from Cape under Rembaum. Alan, you're based out of the Orlando office, correct? You're
Correct.
a managing partner, firm member, board certified in condominium and planned business development, right?
Plan
Did I get that?
development, but that was
Planned
good.
development.
I'm impressed.
Okay, good. Good.
Very close. That was good. All strictly on memory. That was fantastic.
Yes, I was like, okay, I have to think about it. So Alan's going to do our next section. I know this has been a long class. Thank you guys for being so gracious, and all of the questions have been great. So I don't want to take up any more time. So Alan, take it away.
All right, thank you. And you know what? I appreciate it. I didn't even need to say anything about my little introductory statement. You took care of it for me. This is great. I want to work with you guys more often.
Good.
All right.
We love working with you guys. So great.
I appreciate it. All right, so hopefully you all can see my screen now. We have the lovely topic of levying of fines, which is frankly my least favorite thing because I think it's a complete waste of time. And then also some financial literacy and transparency issues are another thing we'll get into. But first, transfer fees and estoppel certificates. So one thing that's important to note, and I literally dealt with this just this week with a client, the association can't charge a fee in connection with the sale, mortgage, lease, sublease, or other transfer of a unit unless the association is required to approve the transfer and a fee for approval is provided in the governing documents. What I want to be clear on is this is not your capital contribution. Those are not allowed in a condo. That is the specific issue that I dealt with literally this week. I won't name names, but they've been charging this capital contribution for a long time now, and technically that has been statutorily prohibited since I made a quick check and right around 2000. So bottom line, you cannot charge some capital contribution fee. I know it's a great practice. It ends up with the association having some extra cash to throw around and do what's needed within the community. The only thing you can charge is up to $150 per applicant, other than a husband and wife or a dependent and parent, which are considered one applicant each. And when I say each, I mean the husband and wife are considered one applicant. The parent and child or children are considered one applicant for this purpose. And that is only something that you're going to be allowed to charge if you actually have an approval process in place. So a lot of communities just kind of throw that charge out there. Make sure you've got at minimum some kind of rule, resolution, or something similar that says that you are actually authorized to pursue and figure out who's going to be residing in your community. If the lease is a renewal, there's no $150 charge because you've already done that. Now, that doesn't mean you can't independently go out and look at criminal records for this person's name, do things like that. You just can't charge them more money. It also doesn't mean you can't still require them to resubmit to a background check. You just can't charge them for it. Security deposits are another issue. If the governing documents, and here it's specifically the declaration or bylaws, say that a prospective tenant needs to place a security deposit, that can be capped at 1 month's rent. It goes into a separate escrow account maintained by the association. It basically is for the purpose of protecting for damages against common elements. In other words, if the tenant does something that causes damage to your buildings, your amenities, etc., that is what this is intended to cover. Now, a practical point that I will throw out there, I have seen it come up many times, unfortunately, where there's no clarity in the form that's supposed to be filled out, or there is no form to be filled out. Who is supposed to get this money back when that tenancy is over? And by the way, I apply the same logic to construction projects that are going on in your community. Okay, you want to make sure that you know who gets this money back when the project, the tenancy, whatever it is done. If not, you may end up in a situation where you're risking being sued because you give it to one party or the other, and the other party says, well, this is my money. If you put something in the document directly that says the tenant gets this back or whoever paid this gets it back, and then record who made the payment, you won't have to worry about potentially having to file a lawsuit to avoid having them sue you. So this is a lot of legal language to say, make sure that it's clear who gets the money back. An estoppel certificate is basically a document that says, here's what it's going to take if you were to sell this unit, or you are to refinance this unit, here's what it's going to take to make sure the association has no problems whatsoever. It's basically, here's what it takes to get back to square one with this condominium or co-op. You have 10 business days after you receive the request to actually prepare this document from someone who's entitled to get it, to actually prepare it and produce it. 10 business days, not calendar days, business days. The association needs to put on its website, presuming you're supposed to have one, a person or entity with a street or email address that you are accepting these notices at. Okay, you're basically saying here's where and how to submit these. They do need to be completed by someone that's authorized by the association. Usually that'll be your manager. And they need to be provided by hand delivery, regular mail, or email. It's almost always going to be email whenever that date of issuance occurs. So let's say you get the request, 5 business days go by, you've got all the information you need, the estoppel certificate is complete, you just email it out for the most part. It does need to be also signed by an authorized agent, which again will usually be your manager. Now that we have a list of the content, I'm not going to go through it in detail because in reality, your manager is going to take care of that. Or if you don't have a manager, you're probably going to contact your attorney to help you with this. We do have a form that I've provided to some clients who just want to know what's supposed to go in here. That will also outline what's not required to go in this estoppel certificate, because there is often a situation where the lender or the closing agent will ask you for information as an association that you don't have an obligation to provide. So this is some of the information that needs to go in there, just the general information. And it's really information about the seller, the buyer, and the specific, or I'm sorry, the seller and the property itself and the community as a whole. Then you're going to have your assessment information. What's actually due? How frequently do you charge assessments? What are the installments? What's the dollar figure? What else is going to come due during the validity of this letter? And we'll get into the timeline on that in a minute. So again, I won't go through in detail, but it's basically what do we need to pay to make sure that when this closing takes place, we're starting fresh and the new owner or the owner who is refinancing is going to completely start over and be all good, completely 100% positive with the association. Then you might have other information on there. So again, there's no capital contribution. You might have other fees, that $150 that I mentioned, other fees, special assessments that are coming up that haven't accrued yet, open violations and rule violations and things like that. Whether the rules actually require the approval of tenants or the purchasers, rights of first refusal that the association might have. In other words, do we get a chance to buy this unit before you sell it at the same or better terms? A list and contact information for all the other associations, if this is either a master or a sub association, and then contact information for all insurance maintained by the association, which I don't understand why that's accessible, but it is. Now, there are fees. I won't go through them in detail, but understand if there's no delinquency, you can charge up to $299. There's additional fees if there is money that's owed to the association. You can also charge the attorney's fees if there's money owed to the association. You can charge a rush fee. And in order to charge any of these fees, keep in mind you have to either have a written resolution, which is basically the board met and decided we're going to charge these fees or something that's less than these numbers, or it needs to be directly included as a charge in the management contract. Usually that'll be towards the end within the either the addenda or the exhibits that say, here are the case-by-case fees we'll charge. It's not part of our monthly fee. The other thing to keep in mind, if this is provided late, now it says within 10 business days, but keep in mind, if you don't provide this within the 3 business days and it was requested on a rush basis, that's also considered late for purposes of a rush. But if you provide it after the 10 business days, you're not charging any fees for this. So just keep these in mind. Again, your manager is 99% of the time going to be taking care of this. But if you don't have a manager, these are things that the board should be aware of. If you have multiple properties, there are specific fees based on the number of units that are being sold. Again, I'm not going to go through them in detail, but know that they exist. These fees are adjusted every 5 years by the government based on the CPI. So just understand that the DBPR is going to adjust those. I think that adjustment happened in 2023, possibly 24. So it won't happen again for a little while is basically what I'm saying. So these fees are probably what's going to be charged for the next several years. and there's not any anticipated change coming up as to what you can charge for these. Now, I mentioned we'll get into the timeline. Again, almost no one sends these by mail. If you do, it's good for 35 days, which means make sure that everything that's going to come due within those 35 days is explicitly included in there. Same thing, if you deliver it by email, it's good for 30 days. Make sure everything's in there. If you find you missed something, or if an owner makes a payment, cures a violation, whatever it may be, you now have a pseudo obligation to issue a corrective estoppel certificate. And basically that creates a new 30 or 35-day timeline. You don't charge for the amended estoppel certificate, and you can charge for a new one if it expires, or in my opinion, if it's a different person actually requesting it, because sometimes you'll have 5 different title agents all requesting a separate estoppel certificate. If I have to prepare a new one and it's not just an amendment, I didn't make an error, the owner didn't make a payment, it's not, hey, there's new information here, everyone's paying for it. Okay. And I don't think that's inappropriate. But if it's the same person asking and the previous one didn't expire and they say, can you just extend it out? Frankly, up to the manager how to handle that. They might be asking for guidance from counsel. There's, like I said, other requested information in connection with this sale, this transaction, whatever it may be. People may ask for additional information that's not listed in the breakdown that we're talking about here. Well, you can charge an extra fee for that. Some of it you don't have to provide at all. Some of it you do have to provide and you can charge for it. And some of it your attorney will have to provide, if anyone. So if there is a request for information that's not in the breakdown that I just provided a couple slides ago of what's supposed to go in here, and your manager's not sure what to do, reach out to your attorney, make sure that it's something that you're actually obligated to provide, and then you can make a conscious decision and an informed decision as to whether to provide it or not. Now, there are other documents that the association might be providing, or the seller might be providing. If you are asked for a question and answer sheet, I don't think that a co-op needs to provide that. I don't recall offhand, but a condo definitely does. And that's going to be updated annually and must be provided to prospective purchasers by the association. So that's not something the owner is going to provide. It's provided by the association. Now, on the other hand, the seller has the obligation to provide notice of all hidden defects. And we don't mention that lightly. We don't mention it because you're supposed to tell the seller about hidden defects. You might not know about them. But if you know about a problem in the community, that might be something that there is an obligation to share with the members. So that's another thing. If you find that there's some kind of major problem, please run it by your attorney, at least your manager. Don't try and hide it, because honestly, I just finished up another webinar, which is why I'm jumping in a little late today. I finished it with a construction company, and frequently when you don't find those things, you don't disclose them early enough, what you end up doing is costing way more to fix the problem down the road. So again, these are unit owner disclosures. I'm not going to worry about it because it's not the association's responsibility, but the DBPR thinks it should be included here. So it's in your slides if you need it. Same thing here, the governance form. This is something the division requires. And again, I'm not going to go into detail. And now we get into some of the fun stuff. So covenant enforcement, I literally wrote the book on the subject. I kind of like doing it. Because the reality is you want to make sure that people are doing what they're supposed to do to keep your community as clean and safe as you want it to be. So we're going to get into some suspensions of use rights and voting rights. Fines is first. Fines, again, I think they're a waste of time. That's why I don't like them. They don't require someone to actually cure a violation. What we're saying is you owe us some money. We can't lien for it because we're in a condo or co-op and the statute says we can't lien for it. We can't charge you more than $1,000 a day for an ongoing violation, only $100 a one-time fee for a one-time violation. So what does that accomplish other than wasting a whole bunch of time, especially in a condo or co-op? In an HOA, if your governing documents allow it, you can at least record a lien. But in a condominium or a cooperative, you don't have that option pursuant to Florida law, period. So my perspective is don't waste your time fining, but consider some of these other options we're going to go through momentarily. But if you want to levy a fine, keep in mind the procedure is the same, whether you're suspending use rights or you're fining someone for a violation of the covenants or the requirements, the rules, whatever you want to call them, the policies. all of the things that tell people what they're supposed to be doing and not doing in your community. Now, the authority to fine, the authority to suspend use rights does not need to be in the governing documents. The authority to suspend voting rights does need to be in the governing documents, or you're not allowed to do it according to Florida law. But let's go through this procedure real quick. Okay, if you want to fine or suspend, and it's for not failing, it's not for failing to pay some money that was owed to the association. Here's the procedure. The board needs to schedule, notice, and hold a board meeting and decide that you're going to pursue either the suspension or the fines against this owner for whatever the violation is. So again, we're talking about covenant violations, different procedure for monetary obligations that we'll get into momentarily. After that board levies that fine, that suspension, you give notice to the owner, at least 14 days notice, that that fine or suspension will be considered at a fining committee hearing. Now, that hearing needs to be held before an impartial committee of at least 3 people that are not related to the officers, directors, or manager. And those are generally the people in the community that are not really the most beloved, okay? Because all they do for the community, because they're not really allowed to do much else as to the official aspects of the community, all they're really doing is telling people you can't use the amenities, you can't vote, you owe the association some money for really no reason, okay? Now, I say no reason, not accurate, but doesn't help is my point. Now, if that committee decides, yeah, you know what, we've heard what the other side has to say, this owner that's being suspended or being fined, we don't really think that they need to be fined or suspended. We think they understand and they've done the right thing. There's no fine. There's no suspension. That committee gets to decide, and that's game over. That's the end of it. The board can't start over with a new fining or suspension unless there is a new violation to be addressed. So what tends to happen, since this committee serves at the discretion of the board, the next board meeting, these people are off the committee. And you cycle through until you find someone who's willing to fine or suspend. Again, it's a lot of time to be spending on this. Now, again, I talked about a fine can't exceed $100 per violation or $1,000 in the aggregate in a condominium. It can't become a lien against the unit. It's due 5 days after the date the committee hearing is held where it's approved. If it's approved, the board generally will be the one to give notice that, hey, you're suspended, you've been fined, whatever it is. If they're disapproved, it just gets kicked back to the board saying, sorry, guys, no luck here. We're not going to do this for you. Okay. Now, if it's failing to pay monetary obligations more than 90 days, and when I say monetary obligation, I don't just mean assessments, I mean fines, I mean rekeying charges, the key fobs that you get at the gate, all of those types of charges, any money that's owed to the association that is more than 90 days delinquent is the proper subject of a use right or voting suspension. Now, again, voting only if the governing documents allow for it. That will only require, because this is related to money that's owed that's more than 90 days delinquent, that is only going to require a board meeting. There is no requirement for this type of suspension or this type of, well, it's only suspensions. There's no fining committee hearing that is required for this one. And that suspension will continue until that monetary obligation is paid in full. So if they owed you, $2,000 and they pay you $1,500, your response is, thank you, that'll be applied to your account, but your suspension is still in place until the other $500 is paid. And if interest and late fees were accruing, and if attorney's fees and costs were accruing, that will continue as well until you're paid in full. Now, for both, the suspension is going to apply to everyone affiliated with that unit. It's not just the member, it's not just the tenant, it's that unit's rights are suspended. Now, the suspension doesn't apply to certain areas. That's going to be limited common elements that are only used by that unit. Common elements need to access the unit, elevators, parking spaces, or any utility services provided to the unit. Now, I get asked 2 questions. What about internet? Depends whether a judge considers that a utility service and whether the association's paying for it. Okay, obviously you can't cut off someone else's non-bulk internet service. I don't think TV is, that kind of utility, but you never know where a judge is going to go. The other one that I get asked about that judges are understanding more and more is eliminating one method of accessing the unit is cutting off the key fob and requiring someone to go, show their ID at the gate. I think that's absolutely fine. It's cutting off one method of access. It's not cutting off ingress and egress to the unit, which is what the statute prohibits. All right, moving on. Voting suspensions, I mentioned, same procedure. Now, there are some differences, though. If you don't have this in your governing documents, you can't do it. Whereas use right suspensions and fines, you have a statutory right automatically. The not the legislature, the courts consider the right to vote more important than the right to use these amenities or the right to not be fined. And so you do have to have this in your governing documents unless you've got special Kaufman language in your governing documents. I don't recall whether that's mentioned earlier in the presentation, so I'll just briefly explain that Kaufman language is basically language that adopts all changes to the statute as amended from time to time. You may have that for certain issues. You may have that in your governing documents regarding every change to the condo statute, or it might not be in there at all. In reality, that's an issue that your attorney will have to provide guidance about. All right, so again, suspension of voting rights for 90 days, delinquency. The amount of the delinquency for this type of suspension needs to be more than $1,000, and proof, not just notice of the obligation, but proof, which could just be your ledger, needs to be provided at least 30 days before the suspension takes effect. What does this mean for practical purposes? If someone goes delinquent 20 days before the election, you're probably going to allow them to vote. Okay. Be careful what you wish for, though. If you suspend those voting rights, that vote doesn't count to establish a quorum or for any other purpose. And so what you're looking at is that person doesn't get to vote. If you're trying to adopt amendments, you're not going to count that person for any purpose. And it might mean that you have less people available in your community to actually vote on anything. All right, I'm going to take a sip real quick and we'll move on to budgets. So, budgeting, the most important thing that I can tell you about creating your budget, other than what Danielle already mentioned about milestone and inspection reports and structural integrity reserve studies, is that your budget is really just your best guess of what it's going to take to properly operate and maintain that community, that condo, that co-op over the next year. That's it. It's a guess. So if you are underfunding your budget, you're doing it wrong, because the board has the legal obligation. I'm sure Danielle mentioned your fiduciary duty as a director, your responsibility to make sure that you're doing what is in the best interest of the association, even if it hurts you, meaning even if it gets you unelected next year. Okay, but it's your legal obligation to put forth a proper budget that will fully operate and maintain the community over the course of the next year. It's not, well, we're going to put off that project because it would cost money. Well, if you can put it off and not detriment the association, okay, maybe that's all right. But if it's something that is necessary for your proper operation or maintenance, you have to put it in the budget. It's up to the members to decide that they want an alternative budget, that they want to reduce funding of certain reserves that are non-structural, that they want to have less money that they have to put in. But you comply as a director with your fiduciary duty by proposing a good budget that's going to fully fund what you really need for that year. The other thing you shouldn't be doing as part of the budgeting process is choosing not to do projects towards the end of the year because, well, we didn't budget for it. So what? If you need to do it, you do it. Now, if you need to hold off for a month or two until you have additional assessments come in because you don't have the money, that's a different story. But keep in mind, when you've got operating funds, not reserves, but operating funds of the association, those can be used for literally any purpose. I don't care, as long as the thing is authorized by the declaration that you're trying to spend money on, and it's at least in the budget. I don't care about dollar figures. I want to make sure that you are properly budgeting for it, not the right amount, but that it's a line item in the budget. You can use those operating funds for whatever the association needs that's an authorized association expense. So you're not going to back into a budget that didn't have enough money in it. You're going to spend the money you need to spend to do it right. If the members have a problem with it, then they can tell you. And you can say, well, we weren't able to accomplish it because the members rejected it. But you as a director, you as the board, have made the decision to do it right, and you allowed the members to get it wrong. That way, you as a director will not be sued for breach of fiduciary duty for not doing what you were supposed to do. All right, Moving into budgets, again, this is your estimated revenues, operating costs, and reserves for the upcoming fiscal year and for the beginning and ending periods and the total assessments for each unit type. One thing that some people do not understand where your assessments come from. Now, I'm not talking special, I'm talking maintenance assessments. Your assessments come from the budget, period. You take your budget, you divide it by the proportionate share that each unit has in your condominium or your co-op, and that's what the assessment is for that year for that unit or that lot in a co-op. That's the whole budgeting process, or at least that's the whole assessment process. Now, there are notices and things like that, but that's how you calculate the assessments. Take the budget, divide it, done. Okay. This is something that a lot of people miss for some reason. They freak out and say, yeah, but where are these dollars coming from? The answer is look at the budget. You'll figure it out. All right, we won't go through in detail what these items are that need to be in the budget. Again, your manager is probably going to be assisting with this. If you don't have one, good for you. You'll have the slides when we leave here today, hopefully, if you fill out your survey, and Jeff will talk about that later. The budget must include these particular items. One of them, surprisingly enough, is not legal expenses. I think everyone should be paying enough or putting enough money in the budget to get a couple legal opinions throughout the year. Many people, I don't understand it, especially in Central Florida where I'm located, a lot of communities do not have a line item for legal in the budget, or they'll budget for $500. Unless you're using an attorney that has no idea what they're doing, that's maybe 2 hours of legal fees throughout the year. Okay. Now, what I would suggest is figure out what you did last year, see if you needed opinions, see if you screwed anything up by virtue of not getting an opinion. Talk to your manager about what they think should have gone to the attorney that didn't because you didn't want to pay the attorney. And think about the fact that 99.9% of the time, in my experience, the people that make the mistake are the ones that didn't bother to get the legal opinion in advance, and they end up spending a lot more money to get out of the problem that was created as a result than they would be spending trying to figure out, well, how do we do it right? The other very important bill, other than your manager, is your directors and officers liability insurance policy. That's the one where the individual directors get sued, the officers get sued. That one's the one that's going to cover you. So make sure that you have that in place as well. That should be in the budget as well. Now, when you're adopting the budget, again, the board is the one that's going to properly notice and adopt this budget at a board meeting. But you need to provide 14 days written notice of that meeting coming up with a copy of the proposed annual budget. So you're going to send out an actual copy of this budget. You need an affidavit from the person that actually mailed these notices, confirming that they were mailed, providing all of the addresses they were sent to, and attaching a copy of what was sent. Now, the other thing to keep in mind, if the board changes the budget during that duly noticed board meeting, that doesn't mean you need to start over. You just send out a copy of the revised budget after the fact, from my perspective. Now, the statute doesn't even clarify that that's necessary. I just think it makes sense to let everyone know, hey, we did make a change. Effective July 1st of 2021, the board was required to adopt the budget at least 14 days before the start of the fiscal year. If you don't do this a second time, it's deemed a minor violation. The prior budget rolls over. What does that mean? There's really no consequence that I can see to failing to actually adopt the annual budget, other than someone might file a complaint with the DBPR. I still recommend, obviously, that you comply with this law, but there doesn't seem to be a whole lot of teeth to, hey, you screwed up. Now we'll go through some reserve terms. I'm sure that Danielle mentioned most of these earlier, but capital expenditures are basically money you're going to spend to purchase or replace an asset whose useful life is greater than a year, or a repair to something that'll extend its useful life for more than a year. So what we're talking about here is purchases, repairs that aren't done once a year. That's pretty much it. And then deferred maintenance is maintenance or repairs that are less than once per year. Now we got some examples here, but bottom line, these are things that you're not replacing, repairing, or maintaining at least once every year. Okay, the budget needs to include these reserve accounts. This has been in the Florida statutes for as long as I've been practicing. Roof replacement, building painting, pavement resurfacing, and then the catch-all, which has been there, which is any other item that has a deferred maintenance expense or replacement cost, which are the terms we just talked about, that exceeds 10 grand. Okay, so anything that's going to cost more than $10,000 that you don't maintain, replace, or repair at least once a year is something you are statutorily obligated to reserve for. What do I mean by reserving? I mean putting that money away. I'm sure Danielle went through the structural integrity reserves earlier. That's really what we're talking about here. Now, how they're computed for structural integrity reserves is look at the reserve study. How they're computed for doing this on your own for some of these other reserves, and by the way, maybe include an accountant, maybe get a reserve study done even if you're not legally obligated to do it, because that'll tell you exactly what the cost is going to be, what the estimated useful life is. And those are the two factors that you really need to decide how much you need to put away every year. So you're going to take the estimated useful life in years and divide that into whatever it's going to cost to maintain, repair, replace that asset whenever it's going to need that whatever. Okay, we basically take the estimated remaining useful life and divide by the total dollars that it's going to cost to repair, replace, or whatever. So for example, if you've got $100,000 roof repair, okay, that's not going to be needed for 20 years. You're going to take that 20 years, divide it into the $100,000, and you basically put away $5,000 a year that's spread among all the members. Now, that's a straight line reserve accounting method. The other option is a pooled method. We talked about, or Danielle might have talked about, how for pooling of structural reserves, the statute doesn't really clarify whether that's allowed or not. Pooling is basically just shoving all of your assets into one batch and putting away what is needed so that every time one of those components is expected to fail, you have the funds for it. You're not necessarily putting that $5,000 in for the roof because the roof isn't needed for 20 years. At least that's what your estimate is. Okay. But the thing that you need next year is really the money that you have to have next year. So it's a little bit more complicated than that, but that's the easier way of putting it is straight line. You're putting away the same correct amount every year to make sure that by the end of whatever that useful life is, you've got the money. In a pooled reserve, you're basically saving enough for each year. That may mean that in certain years, your reserves are more than other years, even though you haven't repaired anything. Okay, so that's basically the distinction between one and the other. You can vote to waive or reduce reserves. Again, this is only allowed for the non-structural reserves. So if it's in your CEUs and it's a structural reserve under the statute, you cannot waive it. You cannot reduce it for any budget that was adopted after December 30th, 2024. Sorry, it took a second to remember that date. The board does adopt the budget with fully funded reserves unless the reserves are waived or reduced by a majority of all the voting interests, not a majority of the board, not a majority of the people that show up at a meeting, but a majority of all votes in the condominium. Pardon me. Now, the other thing to keep in mind, I mentioned full funding. A lot of people get confused about that. It doesn't mean that $100,000 roof repair, we've got the money next year, but we don't need it for 20 years. It means that you're putting that full $5,000 in if you are doing a straight line reserve for this coming fiscal year. So you're putting in what would be required under your reserve schedule. It doesn't mean you have every penny that you'll need for everything that needs to be fixed over the course of the next 50 years within your building. Okay, so full funding just means you are funding the full amount for that year, not funding the full amount for that asset. Now, the vote to waive or reduce reserves is only applicable for the budget year the vote was taken, meaning you can't do it for 5 years in a row. We're just not going to reserve. Whether to submit the vote to the membership is totally up to the board and is not required by law. So understand when you create that budget as a board, if you got one person in the entire community that says, I can't afford that, we're not doing that. No. Okay, well, we are doing that. And if you can get enough people to require a special meeting to adopt an alternative budget, have at it. We don't mind that, but we're not going to screw it up is your response. If at the meeting there's no waiver or reduction or a quorum of the members is not attained, the reserves as fully funded will go into effect. Now, keep in mind, you can only use those reserves for the intended asset. If you've got a pool, you can use it for any asset in that pool, just like I just described for basically all of your operating funds. Okay, it kind of works the same way. If you've got a pool, you can use the funds for anything in that pool. Anything that's outside that pool would require a majority vote of the voting interests. Anything that's in a pool or a straight line for a structural integrity reserve cannot be used for any other purpose, except in true emergency situations, which we'll get into later. Okay, but the other thing to keep in mind, if it's not a structural integrity reserve, but it is a reserve, you might be able to use it for another purpose, but only with a member vote and a majority of all voting interests. Note that it used to be that you only needed a majority of a quorum. That is not the case anymore. Okay, I think it was either last year or the year before, it changed to you need a majority vote of all voting interests. Moving on, if you do not maintain reserves or you waive them or reduce them, there are special disclosures that need to go into your proxy for voting on that and into your financial reports at the end of the year so that everyone knows, hey, we're not putting this money away. It's entirely feasible that as a result, if something fails, we're going to need a special assessment. It's not saying we are levying a special assessment. It just says there is a risk. Okay. Now, moving on to, okay, our year is done. We're going to create our financial report. Within 90 days after the end of the fiscal year or annually on whatever date the bylaws provide, the association is obligated to prepare and complete a financial report for the preceding fiscal year. What level of reporting is required, we'll get into in a minute. Okay. Within 21 days after the financial report's completed, or received from a third party that you're using to create it. For example, if you're at the level that you're using a CPA or someone else to prepare that financial report, you've got 21 days after you get it back from them, but no later than 120 days after the end of the fiscal year, to mail or hand deliver to each owner a copy of the most recent report and notice that a copy will be mailed or hand delivered to the owner without charge within 5 business days upon receipt of a written request. I don't know why that's an end that you need to mail it and then mail it again. Doesn't make sense to me at all, but thank you, legislature. Moving on. The association must provide an annual report to the department, which is a state entity containing the names of all the financial institutions where you maintain accounts, and a copy of the report can be obtained from the department upon written request. Okay, we talked about level of financial reporting. I call this the mo money, mo problems paradox. This is basically the chart, and I won't go through it in detail, but keep in mind, as you have more and more money coming in as revenue to your association, you need a higher and higher level of financial reporting. So number 4 here, if you have less than 150 grand, you basically have a spreadsheet of here's what we brought in, here's what we spent, here's the category of each one of these expenditures and revenues, and here's the date that it occurred. It's pretty much it. That's your financial report, is your spreadsheet. QuickBooks is probably more than you even need for that type of community. I'm not saying don't use it anyway. It's probably much better to use an actual piece of software, but bottom line, you don't need any kind of oversight, overview, review, etc. As you move down the list from 1 to 3, you go from, well, we don't need any oversight to there's some oversight, and then finally you get to the bad mamma jamma number 3, the audited financial statement, which is literally a CPA looking at every document that is in the official records of the association since the last time you had that audit performed. Now, keep in mind, you're going to get statements that say, they might have notes in those financial statements. Don't ignore those. Some of them are actually pretty useful. I've actually had situations where, an association wanted to get out of a contract with a vendor, and the notes to the financial reports, because they looked at the contract, the notes said, well, there's no signed copy of this contract anywhere in here. Now, I don't think that that's good enough to just get out of a contract, but at least it's a negotiating piece that the association was able to use because they had actually looked at those statements. Now, they brought it to us after the fact. It's not that we didn't realize that it wasn't signed. Don't worry, we're not missing those pieces. All right. So moving on from financial reporting, you've got your notice and meeting requirements, insurance requirements, and conflicts. Member meetings, literally what they sound like. So you've got 2 different types of meetings in a community association. One is a member meeting. The other is a board meeting. Guess who gets to vote at each one? That's the distinction. So the members get to vote at member meetings. The board gets to vote at board meetings. The members get to speak at all of them with limitations that you can put in place and should put in place, in my opinion. And that's it. So now you got 2 different types of member meetings. One is the annual meeting. That's where your election is going to be held. It needs to be held within 45 miles of the condo property. We'll get into, I think, elections later, unless that's already been done. The bylaws need to provide a method of calling the meeting, including the annual meeting. The election needs to occur on the date of the annual election. I'm sorry, the annual meeting. Now, keep in mind in an HOA, that's a little different. It's in conjunction. So if you are on both types of boards or you're managing communities, keep in mind, this is a distinction between HOA and condo. There are fewer and fewer every year. The legislature seems to be pushing the HOAs towards the condo statute, but keep in mind, this is still one distinction. It has to be held on the date of the annual meeting, not just in conjunction in a condo setting and in a co-op setting. Now, the location should be provided in the bylaws. If not, it needs to be within 45 miles of the property. It may need to be held in a location that's accessible to physically handicapped people if that's requested. Keep in mind, this is one of the policies that I think every community should have is member participation at meetings. How do you do it? What are the limitations? Who gets to speak and when? How do they get to speak? Is there a limitation on the content? Meaning, is it only items on the agenda and only at the time that they're being discussed, etc.? So that member participation at meetings policy is one I think everyone should have. Another one that I think everyone should have pertains to a lot of the issues that we're talking about now with handicapped individuals. Your disability policy. And it's not, well, they need to do X, Y, Z. It's how are we going to review to get the association away from trouble in denying a request for an amenity, a reasonable accommodation, which is basically, hey, you have this rule. I'm handicapped. In order to use the property the way that I need to be able to use it, you have to give me that accommodation. To avoid getting in trouble with things like that, we do provide to some of our clients that ask for it, kind of a breakdown of the process from start to finish on how you evaluate those types of requests. All right, moving back into the materials, special member meetings. They're literally any meeting other than the annual meeting where the members get to vote. That's it. It's that simple. It sounds special and crazy. It's not that crazy. Now, these are held when the board decides to have one, which could be, let's say, for example, you didn't have your proposed amendments ready by the time that the annual meeting was coming up, or you didn't want to have both of those issues addressed so that your member meeting is 5 hours long. You want to just have one done, and then 3 months later, you'll have the meeting to vote on the amendments. Well, that would be a special member meeting that the board would schedule. Now, alternatively, at least 10% of all unit owners can request that the board schedule this meeting instead, unless a different percentage is provided in the governing documents. Now, every meeting needs notice. You can't just have board meetings or member meetings without providing notice to the members or the board. The meeting notice for every meeting of the association, including member and board meetings, needs to have an agenda. For member meetings, it needs to be mailed, hand-delivered, or electronically transmitted at least 14 days before the meeting and conspicuously posted on the condo property at least 14 days before the meeting. Now, the board needs to have a rule. I call that a policy as well. Realistically, it can just be a board resolution, but it's going to designate a specific location on property where those notices are going to be posted. If there is nowhere that it can be posted, that rule doesn't apply. Now, keep in mind, if you have grass that's at the entrance to your community or a monument wall next to your community entrance, and you have the ability to stick a piece of paper on there, you have a location you can use. It's not ideal, it's not pretty, but it is sufficient under the law. Now, the other thing is the notices for the association, all notices for the association, go to the mailing address that each owner has designated for that purpose. So if someone said, yeah, I don't live at the unit, please send my notices to this mailing address. That's where the notices go, not just to the unit itself, because you're pretty much guaranteeing that the person doesn't get those notices, which is a violation of due process if they don't get the notice. So, or at least if you don't provide it in the manner that they've requested. Proof of that notice, we mentioned the affidavit earlier that's going to go in the official records of the association. Unless a unit owner waives the right to receive that notice, the notice needs to be hand-delivered, mailed, or electronically transmitted. It's going to be not hand-delivered, is my perspective. You're going to mail it out, or anyone that is opted in to accept electronic notices, basically emailed notices, you'll send it to them that way. Keep in mind, anyone who has provided their email address not for purposes of official notices, but just to get email blasts and things of that nature. That is not an official record. And that is not an email address you can use because they haven't opted in for official notices sent that way. You can't use it for the purpose of sending these notices. You can use it as a secondary delivery method and still mail it to them, but you can't presume that the notice is completed just by emailing someone who hasn't opted in to receive emailed notices. All right, CCTV, I won't go through if you're using that. Hopefully you're running it by counsel first. And I talked about the electronic transmission. That is something that the association's allowed to do only for members who consent in writing to receive official notice by electronic transmission. Good news, last year, the writing that is required can be just a form on your website that they fill out, complete, click through, and it automatically submits. And now hopefully the system that your manager is using has that email address already set up and in play, so that they uncheck the mailing tab in their software and recheck the electronic transmission email button in their software. Now, keep in mind, if an owner asks to get service by email of these notices, it's their responsibility to make sure that it's delivered. In other words, once you send it, your obligation is completed. If they stop using that email address but don't tell you to send it to another email address, if their inbox is full, all of these things are not the association's responsibility. So if that email bounces back, yeah, it might be a good idea to take a look, make sure you spelled the email address correctly. But if you did, not your responsibility to make sure they receive it. Now that consent to electronic notices can also be revoked. It can be replaced with another email address. So be careful if an owner submits a second request to make sure that you update that email address or take it out if they're not agreeing to accept notices that way. You can't use electronic notices for a recall of a board member, which is basically trying to pull someone off the board. Doesn't matter whether they did something wrong or not. It's just a vote of the members. You can't use it for electronic notices for that purpose or to forego retrofitting for fire sprinkler systems. Okay, hopefully everyone's already done that retrofitting vote and you're done with it. That was a couple of years ago. That was a big issue, but hopefully you're done. The notice is effective when it's sent regarding each meeting, and a unit owner who says they'll get notices is responsible again for removing or bypassing filters that block receipt. So if you end up in spam is one more reason that an owner might complain they didn't get a notice. Again, that is their responsibility. Now, the association does need to maintain the email address and fax number of anyone who consented to receive notices that way. That is subject to inspection, unlike those email blast email addresses. The association does ensure that the address is used only for the business operation of the association. You can't sell or share those email addresses with third parties, but again, you do have the obligation to produce them for inspection. I suggest, and I don't know many communities that are doing this, but you might want to make it a violation to request to inspect those records so that an owner can go back and sell that information, because I have seen that starting to pop up more frequently lately. Now, we talked very briefly about websites. Keep in mind, as of now, if you have 150 or more units, the association needs to post certain things, including notices on the website at least 14 days before any member meeting. Any documents that will be considered during that meeting, for example, the amendments to your declaration that I mentioned earlier, those need to be on the website along with the agenda at least 7 days before that member meeting. So keep in mind, if you're going to vote on documents, they need to be up. That includes any contract the members get to vote on. If the members get to vote on a budget for some reason, 7 days before that meeting, it goes on your website if you're required to have one. Now, if you're not required to have one, you don't have to do any of these things from my perspective. Now, we'll talk about some of this stuff later. Now, keep in mind, this says 150 or more units. Don't forget that the statute changed this year. As of January 1st, 2026, if you have 25 or more units that your condo manages, you will also need to have this same website and the same information on there. So if you're a little bit smaller, now's the time to start getting that set up. If you're working with a management firm, most of them, including I know I've worked with GRS before, they have this set up for you, but you might need to let them know we want that additional service. Okay, usually Your management portal that every member gets to go into will have 99% of the information that should go on the website. But these notices that need to go on, the agendas, the documents to be voted on, need to be on a separate page that you should be asking management to make sure that they're setting up for you. A quorum is a majority of the total voting interests at a meeting of the members, unless your documents say otherwise. One easy way to make sure that you can actually have member meetings is to do an amendment to lower that quorum. Make it so that it's less than a majority of the voting interests that get to make a decision. Even if you make it 2/3 of 20% or 2/3 of 1/3 that need to vote in favor of something to adopt it, at least then you're giving the members the chance to have their voices heard. If you can't have a member meeting because you can never attain a quorum, the members don't really generally feel like they're being heard because they don't really have any rights other than those provided by the statute, but they can't make changes is really the problem. All right, decisions are made by a majority of the voting interest present at a meeting where a quorum is present, and any approval by unit owners that's required by the Condo Act or the governing documents can be taken by written consent instead of a meeting. Now, you still need at least a majority of the members or whatever your quorum is to sign those written consent forms, but you can do almost anything in a condo by that written consent instead of doing it by having people have to physically show up. I mentioned member participation at meetings as one of the policies everyone should have. So we've already gone through some of this, but members do have the right to speak. The board should adopt, and when I say the board, I don't mean the members, I mean the board should be adopting reasonable rules governing the frequency, duration, how long can you speak, 3 minutes for agenda item, unless you don't have a policy, which might be forever, and the manner of member statements. When do they get to speak? How often? Can you cede your time to somebody else? Because that's another issue I've seen pop up is, well, you know, we really only have one person that wants to talk, but everyone around them is saying, oh, you can have my time. Well, there goes your meeting. You're done. Okay, so have it where, you know, these rules are clear and they state what can and can't be done. Now, the right to attend a meeting as a member also includes the right to record the meeting. Okay, you can record, videotape, but this is also subject to reasonable rules. You can say that you can't use flash photography, that you can't provide any kind of distractions. You can't be running around, taking your cell phone and shoving it in the face of each person that speaks at the meeting. You need to stand in back, and as long as you're not interfering with the ability to actually record that, etc. So bottom line, have your attorney prepare some rules regulating how and when members get to participate. You'll be limited in what you can adopt, and you can kind of adapt it for what your board wants to allow the members to do to some extent. But at least then when you've got your problem child in the community, they can't completely interfere with the ability of the association to do business the way that it should. Voting by proxy, general proxies are basically documents that allow the person that it was given to vote however they want on any matter that's undertaken at a specified member meeting. It's not going to be the equivalent, by the way, of a power of attorney, which is a different kind of document. It's not, well, you're my proxy for every meeting going forward. It's you're my proxy for this upcoming meeting for this purpose. A limited proxy lists the issues the proxy holder is allowed to cast that vote for. Okay, so it's limited proxy. It's not just a, hey, do whatever you want. Limited and general proxies can both be used to establish a quorum. You can't vote by general proxy, but you can vote by limited proxy. Limited proxies must be used for votes taken to waive or reduce reserves, votes taken to waive financial reporting requirements, votes taken to amend the declaration or other governing documents, and any other matter for which the Condo Act requires or permits a vote of the unit owners. What does that mean? You're going to use proxies, okay? Get used to that word, get used to what it means, get used to how to use it. Now, unless use of a limited proxy is required, general is just fine, okay? And your attorney should really be the one telling you which one needs to be used for any particular meeting. Generally speaking, general is not really used very often. A proxy can't be used to vote in an election or to forego retrofitting, as we mentioned. It's effective only for that meeting and any continuation or adjournment up to 90 days after the original meeting date. So if you get that proxy and you say, well, we didn't get a quorum at this first meeting, we're just going to go ahead and push it out a little bit. Well, if you pushed it more than 90 days, then any proxy you got for that original meeting date is no longer valid. Now, every proxy is also revocable at any time because the member decided they wanted to vote or they wanted someone else to vote for them. So keep in mind, there needs to be some kind of effective revocation. It's not just, I'm going to send out another one. Okay, that just creates confusion. So if you're going to revoke a proxy, there should be a document that says, I revoke my proxy, I give my proxy to this person, or I revoke my proxy, here's my ballot. Now we move into board meetings. Okay, board directors has a fiduciary duty. We got into this a little bit earlier. That fiduciary duty is the obligation to do what is in the best interest of the association, even if it hurts you. The good news is the bad news is that is one of the highest duties imposed by Florida law. You're basically a trustee of the association. The good news is it's judged by, and I know my partners don't love this term, but the dumbest guy in the room standard. Okay, it's okay not to be right if you reasonably believed that what you were doing was in the best interest of the association. So you can use your business judgment, not your emotional judgment, your business judgment, to be wrong on occasion. You shouldn't be trying to get it wrong. You should be trying to get it right every time. And you should exercise your best efforts. Okay, you want to purchase insurance, rely on advice and guidance of experts. Get that legal opinion. Ask your manager whether this is the right way to do it. Don't just sit around and say, well, we're just going to guess. I think this is fine, right? This contract for $5 million, we probably shouldn't have an attorney review this to make sure that it doesn't completely screw us over, right? That'd be kind of a waste of $5,000 on a $5 million contract. It's things like that. You get your advice from your engineers, your architects, your attorneys, your landscape architect, your manager. Make sure that you're getting that guidance. The good news is when you get that guidance, relying on it becomes part of your business judgment. So that means that you're held even less responsible, even if you get it wrong. So make sure that you get that guidance and you rely on it. The other thing to point out, directors can't be compensated unless it's authorized in the bylaws, unless it's for work performed in your own trade with all the conflict of interest disclosures that we'll go through in a minute, and abstaining regarding decisions made on the project, or it's something that every member of the community got. You're not being compensated just because you're a director or officer. Now, keep in mind, 90% or more of the decisions that are made for your condo or co-op are made by the board. The members really get to vote on who's on the board, whether to pass amendments, and sometimes whether there's a recall and whether or not a material alteration of your common elements should be allowed. Occasionally, whether or not to adopt a budget that's higher than it's supposed to be under the statute. Okay, but that's really the only things that the members vote on. Everything else, almost everything else, is a board vote. That's a lot of power. And some condos have, millions and millions of dollars in their budgets that's controlled by a group of 3 to 7 people. Okay, that sounds crazy. So I need you to understand, as a director, you're running a business. You're not just running your community. You're not just the guy on the board, the condo commando. You are running a business. It's not a for-profit business, but it is a business. You have corporate powers under the Not-for-Profit Act. Okay, you're not just running a condo that doesn't mean anything to anyone. This is a very important job. It's a volunteer job, but it's an important one. Another thing to keep in mind, no director or officer, not even the president, should be making unilateral decisions unless the power has been granted to them by the rest of the board, or it's a true emergency, not, well, I thought this contract was important, so I signed it. That's not an emergency. The building was going to collapse, so I signed the contract to keep it staying afloat and put all the structural stuff up that needs to be put up to avoid the balconies falling down. Yeah, that might be an emergency. The contract to redo the roof that you need to redo within the next 3 years, not an emergency. Run it past the board, period. Now, the board is generally responsible for the maintenance of the association property. You do have health, safety, and welfare powers, or what we call them. And in line with that fiduciary duty, there's no free lunch as a director. So we said you can't get paid. You also can't accept a kickback, which is basically accepting something that has some value that you're being offered by virtue of being a director. That could include someone coming in and painting your unit for free or for a discount because the association that you had vote for them as a board is going to use them to paint the exterior of the buildings or the interior walls or whatever it is. That's a kickback. Can't do it. It's technically, well, not technically, it is a crime, a misdemeanor under Florida law. Anyone who knowingly accepts one of these, actually, I'm sorry, I said a misdemeanor. It's actually a third-degree felony in Florida, subject to civil penalties as well, and that person is removed from office with a vacancy declared. There's no prohibition, however, against accepting these things in connection with trade fairs or educational programs. This is an educational program. So if we were doing this in person and I handed you a notepad and a pen through, yep, Jeff's got some of our swag there, our nice, lovely pens. If I threw a stress ball that we have at our table all the time at Jeff, which I tend to do anytime he's at one of these trade shows with me, that's something you're allowed to accept because it's part of a trade show. Now, don't accept a TV from a potential vendor just because you're at a trade show, but you can accept the little knickknacks, the little swag bags and things of that nature. Similarly, you can accept something in connection with a trade fair, like I mentioned. That's really going to be your, Condo and HOA Expo, your CAI trade show, your CAMU trade show, and any of the other trade show events, SCCA. All these are things where you can accept swag from vendors that you're considering working with.
And Alan, the inevitable question, which is going to come up 17 times if we don't address it now, people will ask, well, how the heck do they give away a TV in a raffle? Well, that's because the organization is raffling it off. It's not any one of the vendors at the table. It's something that the organization providing the event is raffling off. So that's the difference there. So just wanted to get ahead of all the questions that are going to pop up.
Appreciate that. Okay. So we've covered most of this. Can't use a debit card in the name of the association or bill to the association for association expenses. This is technically theft in the amount that was spent. My recommendation, use a debit card in your own name and get reimbursed, or use a credit card in the name of the association or your own name. Done. Then you don't have an issue. Now, when it comes to these types of charges that are listed in this first bullet here, keep in mind, this is not just someone said you did it. This is not, John, the other director, or Jim, my neighbor, hates me, so he decided that I'm guilty of forging a ballot envelope or a voting certificate. There is an actual criminal charge that is pushed forward by a prosecuting attorney that thought there was enough evidence that this actually occurred to bring charges against the individual. Okay, so if those criminal charges are brought, that person must be removed from office. The person that was charged, not the person that made the charge. Okay, that person is off. The board must fill the vacancy. Well, a lot of vacancies are just, you may fill the vacancy. This one you have to until the end of the suspension or until the end of the director's term, whichever is first. If the term's not expired yet, which is usually going to be the term is every year, but if that term is not over yet, and there's a finding of no guilt, there's a finding of, basically the charges are dropped, then the director and officer must be reinstated, whether you want them to be or not. So this is a removal. It's not just a suspension, but they are automatically back on if they are found not guilty or the charges are dropped. Now, if a director or officer has charges pending, they cannot be appointed to a position or elected to a position as a director or officer of any association, and they can't have access to the official records of the association except pursuant to court order. So I'm not suggesting that you go out and do a criminal background check on every director or do one every time someone submits a records inspection request. But if you know that this is happening, these are things to keep in mind. This person's been charged. We know that the charges have not been dropped yet. There's no finding of not guilty yet. Sorry, but you need a court order to get these documents back. How to get off the board? You resign, you get recalled, again, removed from the board. You're delinquent in the payment of any monetary obligation due to the association for more than 90 days. You are treated as having abandoned your seat because you're not paying your assessments. Presumably, you care enough about the community to volunteer for this role. That doesn't mean you get out of payment. Okay, you've got these criminal charges that we talked about. Any other knowing and willful violation of the Condo Act, the division can be the one to remove the director and levy fines against the director. and failure to take this class and submit your certificate to your manager or put it in the official records in some other way. Note that that's a suspension, not a removal. You'll be given, basically you can be replaced, but once you take the class, you jump right back on the board. The other way to get off the board is, hopefully, I know we're in Florida, but still, if you pass away, you're not supposed to still be on the board. Now, the question pops up pretty often, what the heck is a board meeting? Is this a meeting, or is it just a couple people meeting up and hanging out? As soon as you start discussing association business, many, and frankly, most attorneys will tell you that if there is a quorum of directors and you're discussing anything related in any way to the association, that is a board meeting and you're required to provide notice and let the members attend. Now, there are exceptions to that, but they're related to attorneys and employees of the association. So basically, from most attorneys' perspectives, I don't necessarily share it, but anytime that a quorum of the board is in the same place or discussing association business, even over the phone or Zoom, that's a board meeting. You got to stop. You got to schedule a board meeting. You have to have it open and accessible to the members. Okay. We won't go into what my opinion is because I don't agree with that, but I tend to get hate mail from other attorneys when I give my actual opinion. So we'll skip it. There are a couple required meetings that came into effect just this past year, this legislative session. If you have more than 10 units, you need to meet at least once a quarter as a board. You need at least 4 times a year. Note the distinction there. Okay, you've got once a quarter having your meetings. This is 4 times a year. Doesn't have to be quarterly. Can be in conjunction with those 4 meetings at the same time. Can be 4 days in a row for all I care. That's all the statute requires. But that meeting agenda for these particular meetings needs to include an opportunity for the members to ask questions of the board. Now, keep in mind, the members get that right at every board meeting, but at none of those board meetings do the members have, or I'm sorry, do the board members have the obligation to actually answer the questions that we're talking about. So let me go back through that quickly. More than 10 units, you meet once a quarter. At least 4 times each year, you have a meeting agenda that includes an opportunity to ask questions. So that is your agenda item during those 4 meetings. Okay. And then separately, you have the members have their time to speak during that 3 minutes that everyone's allotted to speak on each agenda item. You're going to give them the opportunity to ask questions instead of stating positions. Again, you don't have to answer those questions at either type of meeting. Now, sometimes there is just no time to schedule a board meeting. I mentioned earlier, you've got a pseudo emergency, or for example, it's something where the members' input is not going to change the board's decision. That is where you can ratify the decision after the fact. So for example, you find a really, really good attorney that you want to work with, but you're only having meetings once a quarter and you don't want to have to schedule another one because no one's available at the same time on your board. And the only time you can schedule this out is if you schedule it for the entire year in advance. Okay, well, technically, if a majority of the board is willing to say, if I attend the meeting, this is how I will vote, then you can sign that contract with that great attorney and ratify the decision by acting as though you didn't make that decision, not lying about it, but going through the motions at that next board meeting and discussing in full, making the motion in full, voting on the motion in full as though there was no contract. Okay, that's ratification. The other thing you can do, and ratification and this next thing are not things that I would recommend doing frequently, but they are an option when you just don't have the ability to hold a board meeting. If the decision is completely unanimous among the directors and your articles and bylaws don't say you can't do this, Chapter 617, the Not-for-Profit Act, also allows you to have what's called a unanimous consent. It's basically a resolution that's signed by all of the directors that takes the place of a board meeting. Again, it's got to be unanimous. It's not all the directors signed and one of them said, I don't agree with this. It's all the directors signed in favor of the same thing. Okay. Now keep in mind, I said what a board meeting is. According to most attorneys, board members can use email as a means of communication, but they can't use it to cast a vote. Meaning if you're going to vote by email, you still need to have that ratified at the next board meeting. You can't just use the emails as proof of how you voted. Now, we mentioned 14 days notice for all member meetings. Most board meetings only require 48 hours notice. And that's going to be just posted in the community. You don't need to mail it out because with USPS operating the way it does, that won't be received for a week anyway. What's the point in mailing it out? Now, if there are certain subject matter of that meeting, such as a special assessment that's not an emergency, or amending rules regarding parcel use or unit use. And again, I say amending, but also creating rules regarding use of the unit. That's a 14-day notice, not just an 48-hour notice. It's still a board meeting, but it's only going to be a different timeline. Now, this is another one. This evidence of compliance by affidavit needs to be in the official records after you send that 14-day notice. Now, again, if it's a special assessment or changes to the rules regulating unit use, that is not just posted, it's also mailed. And by the way, it's also posted on the website for all these notices if you have one or if you're required to have one. Again, the posting location is going to be the same as the location for all the member meeting notices that we talked about earlier. And we talked about website posting. You're just going to post this on a separate page. That's the front page that either all of those notices are posted directly, or you have a separate link on the front page that says notices that you can click on to access every notice, every meeting agenda, and all of the documents that are going to be contemplated during those meetings. Every board meeting has to have an agenda. It needs to specifically state what's going to be contemplated. It is no longer good enough to just say old business, new business, do we have a quorum, close out the meeting. That's not good enough anymore. You have to be specific as to what's going to be discussed. Now, frankly, that's a benefit to the association as well if you've got that member participation at meetings policy in place, because that means that the things on the agenda are the only ones that the members are going to get to speak on, except for when they have that right to ask questions in 4 separate meetings throughout the year. Anything that's not included on the notice can be taken up on an emergency basis by vote of a majority +1 of the board members. But generally speaking, you still need to ratify that at the next board meeting, and only if it's an emergency. Separately, if 20% of the voting interest petition the board to address something, the board within 60 days after receiving that petition need to place it on the agenda for the next board meeting or a special board meeting called for that purpose. So if you're quarterly and you just had your meeting and you get this petition, you're going to have another meeting that you didn't expect if you get this 20% of voting interests. Now, once you get that, that's something that I would submit to your attorney to take a look at and see if all of those submissions are actually valid ballots. Because frequently people will not sign it, they won't date it, they won't put necessary information identifying the unit that they're voting on behalf of. And if we can't verify that this is a valid request for a special board meeting, my response is you don't have to have one. So this is something, again, get it to your attorney right away because you're limited in the time that you have to actually schedule and hold that meeting. If an agenda item relates to approving contracts for goods or services, that contract needs to go along with the notice and made available for inspection and copying if someone asks for it, or just make it available on the website through an app that can be downloaded on a mobile device. In other words, throw it on the website and you're done. Now, if you're considering regular special assessments during this meeting, you do need to specify that during the meeting, those types of assessments will be considered. We talked about member participation. It's exactly the same in a board meeting versus a member meeting. The only distinction is who gets to vote during that meeting. Again, adopt those reasonable rules. A quorum of the board is a majority of the directors. Now, I get the question frequently, well, we're supposed to have 5 people on our board according to our bylaws. We only have 3. My perspective is it is a majority of the board to have 2 people there if you only have 3 directors. Other attorneys will say otherwise, and there's really nothing specific as to case law that I'm aware of on this point. So be careful. If you can appoint those other 2 people, it's almost always going to be a good idea to do it anyway, but just understand there is that risk there. I know everyone loves that I can point out risks for them. But, I'd rather they don't exist. I'd rather the statute be clearer, but it is what it is. There's only so much we can do to try and have the legislature clear some of these things up. We need to focus on the more important parts of the statute, which right now happen to be the things that Danielle talked about earlier. When a telephone call or a Zoom conference is being held, the directors are counted towards having attended as long as the membership can hear them. Okay, so you need to hear the conversation. Now, all of the directors can appear and vote not only via speakerphone, but by video conference. That doesn't mean your entire board meeting can be held via Zoom. What it means is that anyone that wants to attend via Zoom might be able to do so, but you might still have to have a physical location where your meeting is being held unless your bylaws say otherwise. Okay, voting. The vote of a majority of the directors present at a meeting with a quorum is the action of the board. That's a decision. Directors can't vote by secret proxy or secret ballot, at board meetings, except that the officers are elected during that organizational meeting right after the election by secret ballot. That is up to the directors. It's not mandatory that that be secret. And frequently what I see is, John, do you want to be president? Okay. All in favor, aye. All against, silence. So unless there is actually a dispute and the members want to, the board members want to have that be a secret ballot, it's not required. It's just that that's the only time for the directors that that vote is an option to do by secret ballot. A director's present at a board meeting must vote. That's my perspective, unless they have a conflict. That's what the only time you can abstain and not be in derogation of your obligation, from my perspective. Your obligation as a director is literally to do maybe 4 things, maybe 5. Okay. You make motions, you second motions, you vote on motions, or you abstain. So you have literally 4 obligations, and one of them generally you shouldn't be doing unless you have an actual conflict. So you've got 3 possibly. Why would you show up to a meeting and then refuse to vote? If you don't like what's being voted on, say no. Vote no. Vote against. Done. Now, the votes or abstentions must be recorded in the minutes. Keep in mind, your meeting minutes are not a verbatim discussion of everything everyone said. They don't record every single person that was at the meeting. It's just, here's the motion, here's who seconded it, here's who made it, here's who voted and how. That's all that needs to go in your meeting minutes. If you're doing more than that, you're potentially putting the association at risk, because I've had situations come up where the meeting minutes were almost verbatim of what was discussed during a meeting. And as a result, we've got directly in the meeting minutes, John said this was a terrible idea. Maybe not verbatim that language, but that was the gist of it. Okay, well, thank you, board, for putting this right into the meeting minutes and providing me the evidence that I told you it was a bad idea before you did it. But if you don't do that and it's only the vote, then all that's recorded is the vote. Now, I'm not suggesting you destroy evidence. I'm suggesting you don't have an obligation to make evidence for somebody else. If they want to keep that video recording, that's the member's prerogative. But the association's obligation is limited to creating minutes that reflect what was voted on, who created it, and how and why, and that's it. Okay. Committee meetings, if there is a meeting of a committee to take final action on behalf of a board or to make recommendations to the board regarding the budget, those are always subject to meeting notice requirements. They can't be exempted, meaning those are the committees that are open to the membership. Budget recommendations and non-final action, if you're not doing those things, you probably are exempted and you don't have to have a notice of those meetings unless your bylaws say that you do. So these are different types of committees. Keep in mind, you're going to want to probably confirm in writing with your attorney whether those are supposed to be open or not. Okay, insurance requirements. I'm going to kind of blitz through this candidly because the reality is there's no clarification of what adequate insurance actually means. You're going to want to run that by your insurance agent and make sure that you understand very well what is covered and what is not in each policy that you obtain. Fidelity coverage is another thing that you need to have for people who control or disperse funds of the association. Usually management will take care of that. If you have a management company, you have a responsibility to insure all portions of the condo, except for those that the members are responsible for. Pretty straightforward. The unit owners, you really can't force place insurance coverage for a unit owner. So you're going to try and force them to do that through an injunction now. The coverage does need to exclude all personal property and everything within the unit, except for the portions of the unit that the association is actually obligated to maintain. Again, that's going to be one of those, hey, association counsel, what are we supposed to be maintaining? Give me the list, and then go through and say, okay, well, here's the list pursuant to the declaration. Association attorney, what about this thing that's not described in the declaration? And then you'll go through item by item to the extent you still need to. But bottom line, you're going to get the coverage you need because that's what your insurance agent is obligated to provide. And if you tell them we need all of the coverage that's required for a condominium like ours, my perspective is it's their responsibility to ask the right questions, what a condominium like ours actually means. Now, there are portions of the community that might need to be repaired after damage actually occurs. The unit owners are generally responsible for any portion of the condo for which that unit owner is required to carry insurance, and any portion of the property not paid by insurance if the damage is caused by their intentional conduct, negligence, or failure to comply with their obligations under the governing documents. The association pretty much pays for everything else through its insurance policy. Cost of any reconstruction work undertaken by the association is chargeable to the unit owner and enforceable as an assessment if that was the unit owner's responsibility. Association doesn't have to pay for any reconstruction or repair expenses due to property loss to improvements installed by the owner, even if the association approved those installments. So keep in mind, if someone added, tile to their porch and you provide as an association just a flat concrete porch, you're not paying to repair the tiles that you didn't tell them to put on. You allowed it and that's it. Conflicts of interest. We'll move on, and we only have a couple slides left. We're doing pretty good. Directors, officers, and their relatives. And we go relatives. We'll talk about the third degree of consanguinity, my favorite phrase. Those people need to disclose to the board any activity that may reasonably be construed as a conflict of interest. What's a conflict? It's essentially you're doing business with yourself, both as a director and a contractor, with a company you own, or with a company that is owned, or there is some benefit to any member of your family within that third degree of consanguinity. Now, I use that phrase twice now, so let me explain what it means. The third degree of consanguinity is grandparents, grandkids, siblings, including step siblings, I think. And I think it's up to second cousins out there. Okay, so we're talking about someone that's got a legitimate and real, meaningful, hopefully for your sake, not guaranteed, of course, because good Lord, but some kind of real family relationship. So if these types of relationships occur, there is a rebuttable presumption of a conflict of interest. What is a rebuttable presumption? It's basically a shifting of the burden of who has to prove that this conflict actually exists. Okay, if there is no rebuttable presumption, then it's on the person who is claiming there's a conflict to prove that one exists. If one of these things happens, so the director or officer is doing business with the association, or they have an interest in that corporation or business that's doing business with the association, or their family members have that type of relationship with the business. Okay, if any of these things exist, then the burden becomes on the director to prove there was no conflict, unless they actually do what they're supposed to do as stated here. Okay, so if you propose to do business in this way, where you've got this rebuttable presumption of a conflict, now keep in mind that conflict, that rebuttable presumption will exist anyway, but you'll have done what you need to do to avoid the problem. You need to get that contract approved by 2/3 of all other directors present at the meeting where it's being voted on. The director that has the conflict can present that contract or that deal, whatever it is, just like the vendor would be able to normally. But when the board is making a motion, seconding, voting, discussing, all of that, those are things that director needs to leave the room completely during that. The purpose of this is so that there's not any undue influence in, hey, you're sitting next to me, you're talking about not working with me. What's your problem? We don't want any of that undue influence. Okay. And that director also, this is the only time that you are recused and you abstain from voting. Any other time you should be voting yay or nay. If the board votes against the proposed activity, there are two options for that director who has the conflict. And I say director, what I really mean is director, officer, relative, or manager. Okay, they need to notify the board in writing that they intend either not to pursue the proposed activity or they need to withdraw so that there's no more conflict. I'm not on the board anymore. I'm going to continue pushing this. Now, if the contract is signed and there was no, if the contract is signed at the next regular or special meeting of the unit owners, the existence of that contract needs to be disclosed. And if any member moves to cancel the contract, then a majority of whoever is present, presuming there's a quorum, can cancel the contract. If that happens, then the association is only liable for what was done through the date of termination, even if it says in the contract that the association owes $50,000 if they terminate early. Okay. If this is not disclosed, that there was a conflict and that contract goes forward anyway, or there's just even a presentation and there was no disclosure and the board voted against that contract, that director is deemed removed from office. The vacancy is filled according to law, which means you probably appoint someone. Now, keep in mind, this is important if you are working with the association as a director and anyone that you are, this is not my buddy is the one that's going to do it. This isn't, oh yeah, we go out and have fun together. And so I'm going to send him some business because I trust him and I like him. This is more, I've got a real family relationship here and I have a clear problem where I am possibly using this person because it's to my personal benefit. That's what's not allowed. Now, keep in mind, a conflict is not necessarily a bad thing. Okay, I routinely give I probably shouldn't say this out loud, but I routinely give a better deal to people who I know and trust. Okay, I won't do it for family necessarily, but people that I know and trust, whether they're family or not, are probably going to get a reduction of hours or something like that. Okay, now the bottom line is it could be a good thing to have that conflict because you might get the best deal of anyone out there. It's not wrong to have a conflict. It's wrong not to be transparent about a conflict. That contract is voidable. The contract terminates upon filing a written notice terminating the contract with the board containing the consent of at least 20% of the voting interest. Now, the earlier one was that you've already disclosed it and the members get to vote. Okay, this is where it hasn't been mentioned. An association, so let me go back through because I can understand if that's confusing. If you've disclosed it, you've gone through all the required disclosures, you got to 2/3 vote, you abstained from the voting, there is still the opportunity at the next member meeting for the members to say, we don't want this, but it requires a larger vote percentage. It requires a majority of those present. If you did not disclose it, the contract is voidable on the vote of at least 20% of the voting interest to the entire association. Could be the same percentage, could be more or less in either direction. This is just what's in the statute. If you're managing 150 or more units, you must post in digital form on the website any contract regarding a conflict of interest or possible conflict of interest. Okay, managers who have a conflict. This is usually going to pop up, and I do work with a couple firms in Central Florida that have a separate arm that provides individual property management rather than community management, okay? Or they provide the maintenance services that you're contracting with a separate vendor, even though it's still under the same overall management firm, okay? If there's that conflict that the manager or the management firm has, there's the same rebuttable presumption of a conflict. And the disclosures must be entered into the written minutes of the meeting. The approval does require 2/3 of all directors present, just like a director or officer conflict. Same thing, the existence of the conflict and the contract needs to be disclosed to the members. And if the management firm previously disclosed the conflict in an existing management contract, which means that managers should be putting this directly into their contracts to make it easier, The conflict doesn't need to be additionally noticed and voted on during the term of the management contract, but at each renewal, it needs to be noticed and voted on in accordance with these requirements. Again, if the board finds the manager did not tell the association about this conflict, the association can cancel the contract with the management firm. If it's canceled for that reason, the association pays only the value of management services provided up through the termination, no termination fees or anything else, or liquidated damages. And failing to disclose that conflict constitute grounds for disciplinary action against the manager or CAM firm. So frankly, most of them will go ahead and disclose. That's all we've got. I'm going to go ahead and close this out. I breezed through that, I guess. And we'll open it up, I guess, to Q&A unless Jeff or Courtney, you've got something you'd like to add.
I just want to
I guess the second half is quicker.
Well done. I mean, you can do this without the slides now. I mean, when you get to that,
You're not
point,
wrong. I'm surprised that we
gets
got through
quicker
it
when
that
you get to
quickly
that.
is all.
Go through, you and Courtney, go through some of the Q&A. What I'm going to do now is I want to clarify for everybody, while we want you to hang out for the Q&A, and you're welcome to hang out for the Q&A, the required part is done. Okay, in terms of material, the only thing you have left to do before you leave, if you choose to leave before the Q&A, go into the chat and click that link and fill out the evaluation. And after you do the evaluation, again, the required part is done. You can go after that. And the evaluation page, I'm going to share that briefly while Courtney and Alan are looking through some of the questions. Once you click on that link, it's going to take you to this here. All right. Excuse me. And once you fill this sucker out, you hit the submit button, and I'll go over this more slowly at the end after the Q&A. After you hit the submit button, this confirmation screen forms a shaded box. And a lot of the things that we mentioned, both Danielle and Alan mentioned during the course of the presentation, all the contact information, Danielle, Alan, and Courtney are right here. Saving the slides, there's a link. Bullet number 5 is to save the slides. And then Danielle mentioned earlier the Condo Q&A form that we referenced earlier. Link to that is right here. The DBPR page containing different forms and publications, resources, some of which are required. Also, you can click here to get to that. And then the new resources section of the DBPR website. They've done a nice job on revamping. It's also available by clicking right there. But again, I'll do this more slowly a little bit later. But for now, I'll kick it back over to Courtney and Alan to go over some of the Q&A.
All right. Let's see. Well, I guess we'll just go through them. Can the board meet with management to discuss how to address action items, or does all activity have to be in an official board meeting with residents? Again, it kind of depends on whether it's a quorum of the board. I mean, this is when you're talking about action items being addressed, that's explicitly a decision being made by the board. So my kind of, well, it could go either way, kind of disappears when this situation pops up because you're explicitly making decisions about the business operations of the association. Now, again, you can do that via email without having a board meeting, or you can have policies in place that make it clear how that decision is going to be made in the future. So for example, you've got your collection policy, there's delinquent accounts, management is authorized automatically to move those forward. Well, why don't we just skip the need for a board meeting altogether? And then you don't need to worry about whether there's a board meeting or not, because you're automating these procedures and making management's life easier. And as a result, frankly, also making the board's life easier. Same thing with a covenant enforcement policy. If someone violates your rules, violates your covenants, violates, whatever your declaration says they're supposed to do or not do, and you've got a policy in place that dictates what's going to happen when that happens, you don't need a board meeting. But to answer the question, in the circumstances you're describing where you're directing management how to proceed, that's a decision being made. So that is a board meeting from my perspective, presuming that there are a quorum of directors on that meeting, whether it's via Zoom, via phone, or in person. All right, Mirtha asks, for several years it accumulated more than $10,000. Can we transfer funds to operating account and keep current security deposits? I don't know what the $10,000, I'm presuming it's dollars, not 10,000 years. But if we're talking about 10 grand here that's accumulated in reserves, which is what it sounds like, then you'd need to have a member vote. to transfer to operating. You talk about security deposits. If it's 10 grand in security deposits, those are staying where they are and not being commingled with any other accounts. If it's operating funds that you've got an extra 10 grand lying around at the end of the year, use it for whatever you want. It's operating funds. So really, Mirtha, the answer depends on what the funds were accounted for originally as to what you can do with them now and whether or not a member vote is needed to be able to do anything with them. So hopefully that helps. Kathy, if the board knows a unit owner did updates and repairs without a permit, does that need to be disclosed by the board to a new owner? Only if it's a violation of your covenants. Otherwise, frankly, you know, unless it's something that might damage your building or that violates your covenants, whereas, you know, in reality, your declaration requires approval of those types of alterations. If none of that pops up and you're not worried about, you know, well, the work might damage some other property in the community, I don't really see how it's your obligation. The other thing is that should be open and obvious that the work was done, whether the purchaser, the new owner, pulls a permit to check and see whether this was done properly or not is not really the association's problem unless and until it becomes the association's problem. So in reality, my shorter answer is it depends what the work was, you know, and whether or not having that permit might mean it was done wrong. David asks, when there's a violation and fine of $100, does the fine increase $100 per day until it reaches the limit of $1,000? The short answer is yes, but that only applies after the board has actually had that meeting to levy the fine. So there's no fine until the board's had the meeting. There's no fine that is due from the owner until after the committee has had the meeting and provided notice that the fine is due. And it's only $100 overall if it's a one-time violation that is not ongoing. So it doesn't just continue accruing because there was a violation. It continues accruing because there is a violation still in place. Hope that helps, David. Susan, what if the board doesn't agree with the reserve study and does their own thing? What can other board members do since there is a reserve study? Tell them they're in breach of their fiduciary duty and that they should be following the reserve study. Or the only alternative in reality, because I had this come up with a milestone inspection report just this week, you can technically get another one. If you want to spend all that money and pray that a different engineer or architect or group operating under an engineer or architect is going to give you a different result. But you can't just ignore it. That's a breach of fiduciary duty from my perspective. Nelson asks, are there any negative items for pooled reserves on paper? It sounds like a no-brainer. Well, the negative impact is that everyone in the community tends to look at it like a slush fund. And the board tends to look at it as, well, we can spend this on whatever we want, when in reality, it's only we can spend this on the reserve assets that are in the pool. It leads to more mistakes, whereas a straight line reserve is, this is what we can spend it on, this is what we're saving for, we've got the money. The other thing is unexpected expenses become very difficult to fund without a special assessment or a loan under a pooled method because you're not putting money away for that particular asset every year. So hopefully that helps. Nelson also asked, can you go over emotional support animals, not certified service animals? Can emotional support animals be rejected for condos with no pet policies? If it's a legitimate emotional support animal, no, it cannot be rejected. Whether it's legitimate or not should be determined based on a whole set of criteria. And again, I would recommend that if you're not already aware of how that works, check out the HUD guidance that was given just a couple years ago. Just Google HUD guidance, emotional support animals. It should be the first thing that pops up. And then on top of that, I would recommend that every community in Florida have their attorney prepare. I call it a policy. In reality, it's just a step-by-step guide to evaluate whether someone's entitled to that emotional support animal. That's usually like a 2.5-hour charge, and it includes forms that the owner can fill out. Keep in mind, you can't require the owner to fill out a particular form, but it's, hey, this will help us review your request. So hopefully that helps. Nelson, Sevi, what is retrofitting? It's physically going in and setting up a better sprinkler system. If your community hasn't already, usually actually you can look at the public records and see if something's been recorded for your condo. It's only required in condos. And if you don't know what I'm talking about, talk to your manager or more likely talk to your attorney to find out whether it's already been done. Steve asks, is it a conflict of interest for a condo board member, president and treasurer, to also serve as president and treasurer of the Condo Association's Master Association Board? My perspective is no, unless and until there is an actual conflict between the two. Now, even then, keep in mind what a conflict is. It's you have an interest in something from the context of what we talked about. There's also the conflict of interest where you're supposed to be serving, you'll excuse the term, but two masters. Okay, not a master and another master association, but you have a legal duty to the board of each one of these two associations. If there's no dispute between the two, no problem at all. But I do represent a community in Central Florida where I represent the master and some of the same people are on the board of one of the subs. That is frankly a very common occurrence. Okay, it's not a weird thing or something that you can automatically say that's not allowed. What you need to do is get advice possibly from your own independent counsel as to what interests you need to keep in mind when you're voting on behalf of each entity. So it can make it difficult for the individual, but it's not a pure automatic conflict of interest from my perspective. Steve, I hope that helps. Irina asks, we know that the owner of the unit with the delinquency and maintenance fees could lose his apartment to the association. How long does it take and how big should the maintenance debt be in order to do so? In other words, when should we actually start collecting and what does the process look like? If someone is, I'd say, up to 60 days past due in their assessments, possibly less, that first notice of late assessment should be going out. There's no reason to hold off until it becomes even more difficult for someone to pay off the balance because you've allowed it to get bigger and bigger over the course of time. So I don't even care what the dollar figure is. My perspective is you should have almost a rule that if it's 60 or 90 days, this is part of your policy that you automatically will send that notice of late assessment. And if they don't pay pursuant to that 30-day notice that they don't have to pay for, then they've given you no reason not to continue the collection process. That process, there's 120 days worth of notices that go out before you can file your foreclosure lawsuit. So you're already giving this person 4 months automatically, plus the time that you waited to start the process, plus the time you add for mailing and processing of the new notices and the recording of the lien, filing the lawsuit. And then usually it's going to take, there are changes to the rules of civil procedure that'll make this process quicker starting in January of this year. So they're already in place for any new cases that get filed. I would say it's between 6 to 12 months after the case is filed that it's been fairly standard. It might be even quicker now. But the bottom line is, if that owner doesn't reach out to you and take the time to try and set up a payment plan, you should not be looking at it as, oh, I feel bad. You should be looking at it as they are cheating my business out of the money that I need to operate. And I don't mean to say that bluntly, but the reality is these people that are not paying, whether they've got a lack of funds or they're just ignoring their obligations, are putting every other member of your community in a position where you're covering their butt until they pay in full. So my perspective is you don't hold off, you don't feel bad, you try and work with them if they try to work with you, but if they just ignore their obligations because they can't afford to pay, honestly, I hate to be blunt in this case, but why do you want that to be a member of your community? If they can't afford to live there, they shouldn't. And I know that sounds heartless, careless, whatever you want to call it, but the reality is if you can't afford to live where you're living, that's why people move out. I've done it myself. Okay, I bought a place in a country club, realized that the fees were not as small as my parents told me they should be. And all of a sudden, because I bought it from my parents, don't laugh, Courtney. Okay, I made that mistake. But I realized, okay, well, the country club fees are what we thought. The assessments for 2 of the communities are what we thought. We weren't told there's a whole separate community. That's like $600 a month that we were never told about.
Yeah.
I can't afford it. So I sold it. If you can't afford to live there, don't live there. Yeah. That's difficult for a lot of people, especially the elderly, people on fixed incomes. But let's be realistic. There are other properties out there that you can live in, whether it's renting or buying. So anyway, James, how's interest income on reserve bank accounts required to be allocated among reserve fund balances? You put it on the account that it's in. Pretty straightforward. Whether that's a pool and you have one account for the entire reserve, or you have separate straight line reserves, that interest just becomes part of that account. Also, can prior year's interest allocations be reallocated in a subsequent year without property owner votes? So you would still need a member vote if you're moving those funds, regardless of how they were attained, whether it was member payments or interest. If you're going to move them out of the pool or move them out of that straight line reserve, you're going to need a member vote. And keep in mind, if those are structural integrity reserves and it's a straight line, you can't move them at all. Those are funds that stay there until you use them. Can interest income from reserves be transferred to operating if the reserves are predetermined to be adequate? Well, regardless of whether you predetermine it to be adequate, you can move those funds if it's a non-structural reserve, but that does require a member vote, so you can't do it without the member vote. James also asks, compilation, review, and audit are all levels of assurance by a CPA. Wouldn't an association be required to have a CPA prepare the financial statements for the required total assessment levels? Well, the compilation does not require a CPA. It can be prepared by a CPA. So really, it depends what level you're at. Yeah, if you're at a level that requires a reviewer and audited financial statement, you need to have a CPA perform them. 100%, I agree. But for the other two, you don't really have to have a CPA because those don't require one. Frankly, your manager or the board can prepare that. All right, Kathy says, besides taking a kickback, what other reasons would there be for recalling a board member? Keep in mind, the kickback is not a basis for a recall. A recall is not just a removal. A recall is a specific procedure that says, I don't care whether you did anything wrong or not. We just don't want you on the board anymore. So a recall is just a removal, regardless of kind of using the contract term, with or without cause. Okay, this is we just don't want you there anymore. We think someone else would do a better job, or we just want you off the board. Removal is a different story. So we mentioned 6 items. I added the death is number 7, but it's basically kickbacks. Let me make it easier for you. Not doing what you're supposed to do with respect to this class is number 1. That's a suspension, not a removal. Okay. Any other criminal violation or violation of the Condo Act for which you are pursued by a prosecutor, you're off until there's a finding of not guilty or the charges are dropped. Hopefully that answers the question, Kathy. Steve asks, is refusal of a president to disclose the technical configuration and use of a camera system or refusal to provide a condo owner to directly access the camera system and its recordings a violation of the records disclosure statutes? No. There are specific exceptions to the records inspection statute. The software and direct access to the association functions are explicitly not something the association has to provide. The other thing to keep in mind is that video recordings are not written records, and the statute talks about written records. So my perspective is that's probably not something you definitely need to provide. The only thing I would say, just to be safe, because DBPR might get it wrong, in my opinion, if you were challenged on it, you provide the recordings, but direct access to it as it's being recording, direct access to the software, absolutely not. That's explicitly exempted from inspection by the Florida statutes. All right. Adam asks, if the condo documents require a membership vote over 400 units, which is ridiculous to try and get even 50 votes, but you have a board member that constantly puts the association at risk, could you adopt a code of conduct that allow removal for cause without a membership vote? Unfortunately, the answer is no. You would need a recall regardless of what the governing documents might say about reasons to remove someone. Now, you say they're putting the association at risk. That might be a breach of fiduciary duty that could be pursued against that individual director. If they're sued enough times, they may decide to step down. The alternative is, it sounds like you're not able to have an election because you can't even get 50 people to show up. But when that next election pops up, you would try and get people to show up and vote to get this person off the board. What I would suggest based on what you're saying is you might want to consult with an attorney that's pretty well versed in this area of law to try and tell you whether, and this is not meant disrespectfully in any way, shape, or form, but frankly, to tell you whether what they're doing is actually contrary to the law and the governing documents or just something you think is wrong. And that, again, is not an indication that I think you're wrong. It's just you might want to get verification before you start pursuing rights that may not exist. All right. Randy asks, so if the president, one of our boards, also works for the developer building another community around us, Are they able to hold title and make decisions to that affect our community while giving them privileges to run haphazard over our community, or should he be removed? The developer is going to get to appoint certain board members until you get to a certain point in the sales of units within the community. If you haven't hit at least 50%, most likely, yes, that person can be kept on the board. You can have a recall, but then the developer is just going to get to put someone else back on, and I can't tell you 100% that it won't be the same damn person. So the reality is they shouldn't be put back on, but you might want to reach out directly to the developer as the rest of the board members, to the extent that you have any, and point out the things that this person is doing that are wrong, that the developer might get sued for after turnover, or even before turnover if they're doing it wrong. Again, I will reiterate what I just mentioned, though. I think Adam was his name. You might want to consult with an attorney that's well-versed in this area of law, because you may think that they're doing whatever the heck they want, but it might be that the developer gets to make certain decisions that you don't like because they're the developer and no turnover has occurred yet. So they get to pretty much do whatever they want, and there's nothing you can do about it. Now, I'm not suggesting you just let this go, but I think it's probably best if you consult with an attorney that knows this area of law pretty well. David asks, can 3 of 5 board members or more meet to discuss something without voting to discuss something without giving notice to members? Again, that's, most attorneys would say that's a board meeting if that something that they're discussing is actually association business. If they're meeting to discuss playing golf next week, that's not a board meeting, because there was no association business even discussed, let alone conducted, which is the term the statute uses. So the short answer is it depends what they're talking about, but if it's 3 of 5 board members, that is a quorum. There's no question about that, and it just depends what they're discussing as to whether that's a board meeting. Daniel asks, if we record a meeting on Zoom for the purpose of the secretary to refer to for writing the minutes, can we delete the recording once the minutes are produced? Once the minutes are adopted, you can delete that recording. But under Florida law, it's essentially until the minutes are adopted, that is the official record of what occurred during the meeting. So I would get those meeting minutes adopted as soon as possible, so that you are in fact allowed to delete that recording if you're going to hold meetings via Zoom and record them. Keep in mind, you don't have the obligation to record those meetings just because they're held via Zoom if you're holding them that way. Jeffrey Glenn asks, what's happened if proposed budget for 2025 was full of discrepancies, missing funds, missing line items, etc., and when residents tried to ask what's happened with those missing items, the treasurer and manager refused and ignored any related questions, misled residents, and finally, manager who put these proposed budgets together admit they're not qualified to create the budget. Nevertheless, even this proposed budget was rejected by the unit owners. It was approved by the board. What's the remedy to fix the budget? It sounds like you probably want to try and gather up enough members to require a special meeting and possibly adopt an alternative budget. Unfortunately, that's the best answer I can give. Again, you're probably going to want to talk to someone who's well-versed in this area of law rather than just presume that they're doing it wrong. Because keep in mind, if you didn't get the required vote of the members, even though a bunch of members wanted it, if it wasn't the required percentage, the board is still obligated to follow what they've prepared, even if you think it's wrong. Now, if it is actually wrong, you might have a cause of action. But again, I would talk to an attorney that's well-versed in this area of law rather than presume that anything was done wrong. Same Jeff also asked, if management companies hold all finances from the association and do the accounting, pay the invoices, create budgets, does this constitute a conflict of interest? No, it does not. A conflict would be if the management company is paying itself after the association said not to, unless that's a term of the contract. So this is not a conflict. Carlos asks, there are 2 buildings, each have their own HOA, but all rec areas have a COA, condo, or an HOA master elected by those 2 buildings. The president of the master could be the president of one of the buildings. Is it not a conflict of interest? Same answer as before. No conflict from my perspective, unless and until there's an actual dispute between one community that they're on the board and another community that they're on the board. Jeffrey Glenn asks also, are unit owners must maintain own insurance policies or not? Yes, they must maintain their own insurance policies to cover anything that's within the unit or their responsibility under the declaration. Elizabeth asks, so the 4 required meetings, does that include the annual meeting? No, because those are board meetings that are required, and the annual meeting is a member meeting. So we talked about the quarterly meetings the board needs to hold, the 4 required meetings where on the agenda you have an item that says members ask questions. Those are both board meetings. The annual meetings and a member meeting, so that wouldn't count. You can have one directly after the member meeting, but chances are there's going to be no answers because you're going to have a new board. Let's see. Valerie asks, what's the statutory requirement regarding the question and answer sheet? You need to have one. You need to produce it upon request, and the content is statutory. It's specific to your community, but the general questions that you're going to be answering are directly from the statute and the Florida Administrative Code. Mirtha asks, the accumulation of more than $10,000 is from security deposits. Yeah, those security deposits that you asked about earlier need to stay within the association funds, separate from everything else, and be returned to the people that deposited them once that need for the deposit is done. Judith asks, what do you suggest when appointed board members refuse to communicate with a new member, and how do you suggest they be effectively addressed? I would suggest that the new member that's being ignored send communication that can't be ignored, or make a statement during a board meeting that they can't be ignored. Now, unfortunately, it is feasible that, a majority of the board snubs the new guy. I don't think it's the right thing to do, but unfortunately, there's just not a ton that we can do about that other than setting up maybe a, part of that member participation at meetings policy. You add some board conduct that is either mandatory or not allowed into that policy itself. And then any violation of that policy, like ignoring someone, is a violation of a rule of the association. The problem is, I don't know that it would be enforceable to say you need to respond to the other directors. So I think you'd be setting up the association for failure and trying to force everyone to be friends is really what we're coming down to here. Miranda asks, what's the procedure to get one out who is not paying their HOA fees? It's a foreclosure. Now, if it's someone who's on the board that's 90 days or more delinquent, they are off the board. They've abandoned their seat. You don't even need to do anything about that. You just tell them, sorry, you're off, you're done, bye. But if it's an owner that's not paying their assessments, then and they're not on the board, then that would be the collection and foreclosure procedure that we talked about in response to one of the earlier questions. Can someone be evicted by the board for non-payment? Yes, that's called a foreclosure. And the eviction would come after the foreclosure is completed. There's a new owner in the property, and they ask for what's called a writ of possession, which is essentially the equivalent of an eviction, but within a foreclosure proceeding after the sale is complete. Lucinda asks, what happened to special assessment monies if they're not being used at the end of the requested of the month? Does it just sit in a bank? Can it be rolled into the pool? Do the length of time waiting for the job to be done? Well, you'll still need it if the job's not done. So you hold on to that money to pay for the job when it is done. Now, if the job is done and there is still money left over and you've gotten all the inspections done, everything is good to go and you're done, fantastic. Move on with your life. You can roll that into the operating funds of the association, but I would suggest reporting to the members that that's what you're doing and let them know that their maintenance assessments will be less in the coming year because you don't have to charge them for that next year. Not month, but 6 months later. Yeah, even if it's 6 months, if it takes a while to get the work done, the work still needs to be done that you levied that special assessment to pay. So I wouldn't just give the money back and then ask for it again when the work needs to be done. Horatio says, thank you. You're welcome. Gloria asks, which DBPR form is needed for the written certification? That's the form that you'll get after you have completed the survey at the end. I think Jeff already put the link in the chat for the evaluation. Once you complete that, the link to pull up, I don't know if you're pulling it up or Jeff, are you emailing it to them separately?
Yeah, people are going to fill out the evaluation. Then we're going to cross-check that with the attendance sheet to make sure everybody here attended in full. Then within a couple of days, everybody will be emailed their certificates to the email address they used when they registered for this webinar.
Okay. Stephen asks, what recourse does the association have to owners who haven't paid assessments or fees and are in default for more than 90 days? Again, you have your collection policy. It says you send a notice of late assessment. Then you move forward until they actually pay. You follow the policy. You end up foreclosing if they don't pay in full. That's your recourse. Okay. Valerie, I'm not sure what statute you're asking me to cite to, so I can't really help with that one. Lucinda, you're welcome. Stephen, is the owner personally liable for unpaid fees in addition to having their unit foreclosed? Yes, unless they've filed for and successfully completed a bankruptcy where they were discharged from the debt. So you've got a Chapter 7 bankruptcy, which is basically I don't have the money to pay, so I don't have to pay. That means that the unit can still be foreclosed, but the owner doesn't get a money judgment against them. A Chapter 13 is I want to reconstruct all of my debt or reorganize all of my debt. Usually that'll entail payment under the bankruptcy plan. And then if they don't succeed in a bankruptcy or none is filed, you will generally get a money judgment as well as a foreclosure judgment. The foreclosure judgment, it's all in one document, but it's going to say if the owner doesn't pay the amount the association is due by a certain date, the property will be sold. Now, the way that the foreclosure sale works is it basically, let's say there's $10,000 owed to an association, property sells for $5,000, the association ends up with it because it's less than what the association was owed. The association will still have a judgment for the remaining $5,000 and title ownership of the property. If someone's willing to bid more than the association's owed, that's actually the goal of the sale, and the association just gets paid through the court system, because that person that bid more than the association will have to pay off the judgment in order to purchase that lot, that unit, whatever it may be. Edwin asked, the windows, vertical closing are the owner's responsibilities, but when they're replaced for impacts, we're requesting for them to be horizontal. Does this need to be approved in a meeting? Thank you. That is going to be a question for your attorney as to what your governing documents require as to material alterations of the building that you are now requiring of your members. So can't give you a direct answer, but that's going to be something to have your attorney take a look at. Valerie's asking for the Q&A sheet citation. I don't know it offhand. I know a lot of statutory sites offhand, but I'm not purely an encyclopedia. My email address is on the screen right now. If you'd like to shoot me an email, I'll be happy to get you that information later on. And Scylla, are there any requirements for minutes information within them? Yes, the minutes need to talk about who made the motion, what was the motion, who seconded it, who voted, and how. Pretty much it.
Thanks, Alan.
All right, I guess that's it. And I gave you guys 10 minutes of your lives back.
Amazing.
Well, that's wonderful.
Amazing.
And I did promise I'll go over the evaluation process and answer any tech questions in a moment. But before we do that, Alan and Courtney, what are your parting words and the best way for everybody to get in touch with either one of you?
You can go first, Alan.
All right, thank you. So parting words, thank you to GRS. We always appreciate, and you in particular, Courtney, always like working with you. I appreciate it. You make life easier, so thank you for that. As to the best way to reach me, my email address, which is on the screen right now, as@kbrlegal.com, or feel free to follow me on LinkedIn. Most of what I post is upcoming webinars, upcoming speaking engagements, or other helpful tips for either attorneys or managers in the industry. So feel free to follow me there, connect. If there's anything I can do to help out, feel free to reach out. And anyone that is in the Central Florida area or further north that is not thrilled with the attorney they're working with, those are the people I'd really like to hear from, because I'd be happy to potentially work with you and help you with the actual issues your community is facing. But again, thanks again to Jeff, of course, always my friend, and to GRS and to Courtney, and thanks to everyone for sticking around. We've still got over 100 people here, and the fact that people were willing to listen to my voice for almost 2 hours is just absolutely impressive. So thank you.
All right, thanks so much, Alan. Great webinar as usual. You're one of my favorite presenters from Cape Under Rembaum. I love everybody at Cape Under Rembaum, but you're really good.
That was a good save.
No, I do. I love everybody, but you make it more interesting and fun, and you have some like quips in there, and I appreciate that. So, and again, thanks to Jeff. You are amazing at setting all these webinars up and facilitating everything. I can be reached. I know that Jeff is going to end the evaluation. My email will be there, but my email is my first initial, my first name, and then my last name spelled out at grsmgt.com. Just like Alan said, if you're not happy with your management company, that's who we would like to hear from. You can get more information about our management services at grsmgt.com. We have social media accounts as well, LinkedIn, Facebook, X, Instagram, all the good stuff. Again, we love doing these things for our board members and our managers. So I know we'll have some upcoming events, and I'm sure we'll be doing more with Kaye under Rembaum in the future. So again, thanks for everybody participating and coming to today's webinar. I think it's amazing that you were able to answer almost every single question, Alan. I don't think I've ever seen that happen. So consider everybody really lucky that you got your questions answered today, because that was amazing.
Thank you.
All right. Well, thank you both.